nothing, but you wanna be something. Yeah. Well, all you really need is hope. I just want you to trust me if you wanna be something.
That's right. Let's go. Yeah, when you're feeling down and you're out, like you got nothing but doubt, you're alone in the crowd, just trying to figure it out. All of this cloud and this money got you feeling left out. Listen up to me now, every word that's out of my mouth. Wake up, it's me. You gonna follow your dreams, or are you just gonna be another cog in the scene? You feel the hope in this beat, yeah, the hope that you need to proceed and be exactly what you want it to be. I feel right and I'm proud, hype and I'm loud. I'ma shout all about how I feel in the now. Ain't nobody ever gonna try to change me till I'm dead, pushing up daisies. I'm alone in the crowd, I won't feel down. I got hope right now, and I know I'll be found. I don't really care just what all other haters gotta say. I know everything I do is gonna make them fade away.
And when you feel like you're nothing, but you wanna be something. Yeah. Well, all you really need is hope. I just want you to trust me if you wanna be something. Yeah. Then all you really need is hope.
Let's go. Yeah, it's what you need when you're down, need when you're out. It's what you need when you're sad and when you feel left out. You feel an energy drought and then creeps out, but with a little bit of hope you can figure it out. Keep your head high even when you're down inside. Through the pain you fight and through the painful nights you keep striving, keep trying, keep driving, rising, keep thriving, surviving. Nothing's in your way but yourself. Don't need nobody's help. You can make it through this hell. Take it one step at a time, one step as you climb. If you fail you'll be fine. Get back up to the grind and never lose sight of your mission. Be driven. This life is a prison if you don't have vision. You're in it to win it, so get it, don't miss it. Your chances now, so be something somehow. Don't let yourself down. That's right. Sometimes all we really need is hope.
Oh my gosh, I've been talking for a full minute. I'm so sorry. Yes, I forgot to unmute my mic. Geez, go figure. I was just telling you guys, sorry that I was late. I was trying to get the intro video up and going and things like that so that we can start today off with a little bit of pep in our steps so that we can head into jury with all kinds of hopefulness that they will find as many people as possible today. I'm hoping for 40. That would be amazing. Then we wouldn't have to do this on Monday, but I doubt that's going to happen simply because we're averaging about 20 a day. So yeah, hopefully this works out though, and they can get as many as possible because I would hate for that to keep dragging on and things so that we can start moving forward for justice for Gannon. Thank you so much for everyone for being here. Hi, Grandma Sherry. Hi, Sean. Hi, BC. Hi, Boo Will. In the bushes. Good morning. Hi, Rexy. Let's see. CO, good morning. Good morning. I know I seen Kathleen as well. Good morning, Kathleen. K Crochet. Hope you're still here, hun. Good morning. I think this process is so important. I honestly, having not really watched very many jury selections at all, period, I feel like we are learning an abundance of information and things throughout this process. Good morning, Hawaiian Mama. And so I've really enjoyed it, honestly, even though it seems like, especially the first like hour drags, right? Because they're asking all of the details about um their their life, why can't they come, what happens, blah blah blah. And so that part's, kind of boring whenever we can't hear their answers, especially. But at the same time, we're all a little bit nosy. That's why we're here. So it's interesting to hear the excuses some of these people come up with. Good morning, Hope. I'm gonna tell you guys something really funny. I was freaking out because I thought that I blew out my speakers yesterday because I turned it up as loud as I could while I was out in the kitchen so that I could hear it in real time when the judge shut off and stuff. And I was following on my phone as well so that I could look at the chat, but I that way because the chat is a minute behind because I do have this set. If you need closed captions, you're able to turn it on, but turning on the latency for the closed captions makes the StreamYard chat run super slow, and so I get behind. And it looks like it feels like it takes me so long to respond to you guys once you type. It's because it's literally a full minute behind, and a minute can be a long time in streaming time. And so yeah, so I was I was listening to it so that whenever the judge shut off, I could come running back, and I thought I blew out my speakers because this morning I was working on this song and this intro and stuff, and it sounded really weird, like really weird. And and so I was like, what is going on? Like, why does it sound like that? I thought I blew out the one side, and it was just because my speaker was half unplugged. So I was thankful to see that because, like, man, can't have more stuff. Good morning, Colorado Mountain Girl. Yes, justice for Gannon. Absolutely. You know, that's what this is all about. This is all about us watching the process of justice for Gannon. I I feel like I need to know that this witch is going to be put away forever. You know, I would hate for her to get the comfortableness of a insane asylum. Not that that place where she would be going is very cozy. Actually a lot of bad reviews about it, but she doesn't deserve a padded, comfortable bed. She does not deserve to be able to see out a window, light of day, and things like that. You know, she deserves to suffer immensely for what she has done. And good morning, Scout. How are you? Yeah, justice for G Man. Justice for G Man. That's what that Sonic stands for, guys. It's the Justice for G Man. I didn't want to use like something that was literally him, like his picture or anything like that. I wanted to do something to represent him, and with how much he loves Sonic, I felt like that was a good addition to our emojis. Yeah, she's definitely not insane though. I totally agree with that. So what we will do is we will go right back to listen or reading through the arrest affidavit on breaks, if you guys are okay with that. Um, and that way, whenever I guess I should leave my glasses on. I was getting ready to take them off and sit them down. I don't know why. But we will go right back through to reading through the arrest affidavit, and we will really try to knock out a big chunk of that during a lunch break. I know In the Bushes plans to join me on lunch today so that we can discuss as we're reading through it. That way it's not just me reading. They started WebEx extremely early today, and so I'm not sure. I'm hoping they will be on time, but they opened it was like 10:15 my time, so that would have been 8:15 their time, and they normally it's not that quick. So, yeah, absolutely, Boo Will. This is a case I was not gonna walk away from, you guys. There was not a chance that I was not going to cover this case. Not a chance. And so this for me, even if it wasn't streamed, I would have been sitting here reading tweets to you guys if that's what we had to do, honestly, because it's just, I have to follow this through for me and for all of you guys too. But for me, I needed to. I would have been watching this, and I love being able to watch it together, to talk about it together, to be a community in support of justice for Gannon and for his family. You think life in prison would be too good for her? Yeah. Oh, man. Yeah, absolutely, Grandma Sherry. Oh, thank you, Boo Will. Thank you. And I apologize to you guys for how scattered I was yesterday during the live that I did in the afternoon. I just I don't normally get that scattered. So every now and then, but not on a regular. There are days though that I can't brain. Okay, so let me get this arrest affidavit back up for you guys so that we can start looking at that because they have not come in yet. We were on page 15. So we were on page 15. They had just started talking about the Blue Star reaction of the areas that there was blood found. Yes, I can't brain. That's exactly right. So let me take down this so that we can do that. And once they come on and start talking, I will switch over to them. We are all human, not tea. Yeah, not tea. But we get it. Yeah, right. I think the problem is, well, I do hold myself at a higher standard because if I'm going to be on here pretending to be something that matters or somebody who matters and that expect you guys to sit here and listen to my opinion and listen to my thoughts and different things like that, then I feel like it has to be done in the proper way and with a certain amount of respect and things towards Gannon, towards his family, towards every case that I cover. And so that's why I get really hard on myself whenever I feel like I messed up or I did something wrong or anything like that. And so um it's just about, the standard that I hold myself to, I guess. Like, and we're not going to be perfect. That's not a reality, but um dang sure would like to try to do the best for them that I can. The best for this case that I can in any case that I covered. Oh, here they come. Didn't even have to start reading.
Good morning, ladies and gentlemen. It's a Friday. We're at the end of the week. Good morning, ladies and gentlemen. My name is Greg. My name is Greg Warner. I'm a district court judge for the 4th Judicial District. Before we begin the jury selection process, I would like to introduce some of the people who are in the courtroom and who you may or may not have already met. Jessica Reedy is my court reporter. That's important to remember because she can only take down what you say. She can't take down nods of the head, and uh-huhs and uh-uhs don't get translated very well. In addition, we're going to be asking questions, excuse me, of everyone in the courtroom as opposed to just the people in the box. So it's really important that the people on this side in the far back speak loudly so that she can hear you, and it makes her job a whole lot easier. You've already met Mr. Sproul and Mr. Combs. They are here to assist you. You can talk to them regarding any general matters, such as parking, phone calls, those sorts of things. However, do not talk to them about this case, and they will not talk to you about the case. They're not being unfriendly. It's just that no one is permitted to discuss anything about this case with you. I assume that most of you were not thrilled when you received your invitation to come join us this morning. However, please understand how important you all are to our judicial system. I want to thank you for being here, and I think you should know that the United States conducts about 90% of the world's jury trials. Many other countries do not trust their citizens to make these kinds of decisions and leaves those decisions to be made by some member of the government. However, when our country was formed, the people who formed our country believed that the government should not have that much power. As a result, they placed in our federal constitution, and our state constitution has a similar provision, for a right to a jury trial. That right cannot be secured unless all of us have the obligation to serve when called. In case you're wondering, yes, I have that same obligation. Yes, I've been sitting in the same seats that you're sitting in. I do understand that it's a sacrifice for you to be here and to put your lives on hold, and I deeply appreciate your participation in this process. Thomas Jefferson said, "I consider trial by jury as the only anchor ever yet imagined by man by which a government can be held to the principles of its constitution." I have spoken to hundreds of jurors over the years, and although jury service was a significant inconvenience, again and again, they told me that they were glad that they had served. They felt that they had done something important, and if given the chance, they would serve again. We are identifying you by number in court rather than by name for a number of reasons. First of all, due to the number of jurors being called, we do not want there to be any confusion regarding who we are referring to at any point in time. There may be more than one Mr. Martinez or more than one Ms. Johnson, and referring to you by number helps us keep track of a particular person. In addition, while the defendant, the attorneys, their staff, and the court personnel will know your name, referring to you by number is to protect you from contact by the media or other persons, curiosity seekers and the like, to protect you from unwanted publicity and to ensure that no outside information is communicated about you through this process and through the trial. Finally, after talking with a lot of jurors over the years, they all told me that they were more comfortable when referred to by a number in open court rather than a name. The fact that we are identifying you by number should have no impact at all on the presumption of innocence that the defendant is entitled to, or any impact in any other way as you consider and decide this case if you are selected to serve. The case we are about to try is a criminal case. The prosecution is brought in the name of the people of the state of Colorado. The prosecution in this case is represented by Michael Allen, Dave Young, and Angelina Gratiano. They are attorneys with the district attorney's office. I will sometimes refer to the district attorney as the prosecution or the people. In this case, the defendant or accused is Letecia Stauch, and she is being represented by Josh Tellini and Will Cook. The charge against the defendant is contained in what is called an information and complaint. An information and complaint simply describes the charge made by the prosecution against the defendant. It is not evidence of anything. In this case, Ms. Stauch is charged with murder in the first degree, child abuse resulting in death, tampering with a deceased human body, and tampering with physical evidence. To these charges, Ms. Stauch has pled not guilty by reason of insanity. Therefore, the prosecution has the burden of proving the charges beyond a reasonable doubt. The jury will decide whether the prosecution has proven beyond a reasonable doubt that the defendant has done the things that are contained in the information and complaint. If I can have all of you stand and raise your right hand, please. Do you and each of you solemnly swear or affirm under penalty of law to answer truthfully the questions asked by the court or counsel concerning your service as a juror in this case? Great, thank you. Go ahead and have a seat. Before we go any further, do any of you have any difficulty either hearing or seeing what's going on in the courtroom? No response. In this case, 12 jurors and 6 alternates will be chosen. They will consider all the evidence produced during the trial. The jurors will determine what the facts are based on this evidence. The process that we have here that we've been going through for a number of days is that we're bringing in 75 people a day. We will keep doing that until we qualify about 110. Then we will bring those 110 back in one group, and we will select the jury from that 110. The attorneys anticipate this case will take 6 weeks for trial. That does not include deliberations or jury selection. We hope to start the presentation of evidence on April 3 of 2023, so that would mean finishing evidence sometime in mid to late May. I understand the burden such a lengthy trial places on people. I previously presided over a case that went 18 weeks from start to finish. So I've been through this before. I understand how difficult this is and how long this is. Our trial days will generally be from 9 to 5, Monday, Tuesday, Wednesday, and Friday. There will be no trial on any Thursdays, as I have other docket matters that I have to attend to. You will be able to go home to your families each day, and though you will not be able to discuss anything about this case with them, you will be able to talk to them about anything else. You will also be able to continue to use the internet and view newspaper stories, all of those things, just not about this case. So you'll be able to go on about your life except for this case. You'll need to avoid everything with respect to that. Knowing this time commitment, is there anyone who believes they would suffer an undue or extreme hardship if required to serve for this trial? Please raise your hand, and I'm going to do this in sections. So starting over here first. All right, let's see, 1, 2, 4, 6, Juror number 6. Yes, ma'am. You said the court date is on May 1? And what is that for? How long is it gonna be, do you know?
No. Might be that day, might be postponed again.
Okay,
It's my husband.
okay,
He was back.
okay. So it's not your court date, it's his. Okay. All right, and when are the major doctor appointments?
One's in April and one's in
Okay,
neurological and cardiology.
and are they for you or for your husband?
Mine's 6 months out already,
I'm sorry?
6 months ago.
Okay. Anyone else in the back? Juror number 9? Did you say it was nursing school? Okay. Anyone else in the back? Juror number 5?
Church plan to New York, April 25th through May 10th. Ticket.
Okay. Anyone else in the back? Oh, all right, front row, juror 13? Yes, sir. Yes, sir.
For a company that's shutting down, part of a small group that is facilitating.
It's taken a while to shut down, I take it. Oh. Okay. All right. And juror 14, did you have your hand up, sir? The gentleman at 14 did, okay, I misunderstood. Is there anybody else in the front row? Oh, juror 15, yes, ma'am.
I have a trip that is paid for May 2nd through the 7th for my daughter qualified for nationals. uh, Documentation probably.
No, what you qualify in?
She is, she's a tumbler, level 5 tumbler. She qualified for cheer nationals in
Okay.
Florida.
All right. Anyone else in the front row? Juror 19?
I am going to be out of the country.
All right. Is there anyone else in this group that I've not spoken with? No. All right. This section over here, front row, juror 24 there on the end. Yes, ma'am. Okay. Okay. Juror 20, juror 25, did you have your hand up, ma'am? No, it was, okay, was not. Okay, juror 26, yes, ma'am. You're going to be having what? Okay. Okay. Juror 27, did you have your hand up? Yes, juror 27. Where do you go to school? Cowboys. All right, and in the second row? No, okay, need you to, yep, raise, there you go. All right, juror 36, yes, sir. Yes, that's you. Cowboys. Juror, anyone else? Juror 37, yes, sir. All right, anyone else in that second row? No. All right, third row, and juror 54? Yes, you, sir, yeah. What kind of work do you do? You do what? Oh, juror 55? Anyone else in that group that that I missed? Juror 49? Okay. Is there anyone else in that group that I missed? This group, first row? All right, juror 30? Oh, I'm sorry, 31? Yes, 31? Yes, sir. Mhm. What kind of work do you do? What kind of work do you do? All right, thank you, sir. Juror 32, did you have your hand up? Okay, then juror 30? All right. Anyone else in this first row? That I want you to hold on to that because that's a separate issue right now, and we will get to that. I promise that we will, and I'm glad that you raised it. Right now, I'm just trying to find out who has a hardship. So, but I'm glad you raised that. Anyone else in the first row? Anyone else in the second row? Juror 46, yes, sir. Okay. All right. And juror 48, did you have your hand up, ma'am? Yes. Okay. Anyone else in that second row? No. And in the third row? Juror 56 on the end? All right. Anyone else in that row? Let's see. Juror 59, yes, ma'am. And what kind of work do you do? And did I see, let's see, Juror 59, or I'm sorry, juror 60, sorry. UCCS. You know how I know that? Because I've had other college students in here from UCCS telling me that when the graduation was. So, all right, anyone else in that third row? Juror 62 on the end. Okay. All right, and juror 61, did you have your hand up? Okay, it helps me a lot if you, teacher, because when you get into the far back, it's hard for me to see that far, okay? So juror 61, yes, ma'am. Okay. And then in the fourth row back there, juror 63 on the end. Yes, sir.
My wife has problems including
Okay. Others in that row, juror 65. Yes, ma'am. All right. What kind of work do you do? Yeah, when is your funeral?
Today at 10.
Thank you for your service. We'll let you go. Juror 67? Yes, sir. And juror 69 on the end?
Graduation.
Wouldn't be able to work nights, so tell me about the work issue.
I'm a custodian at Manitou High School. We work from 1 to
Well, what I'm trying to convey here is if you are selected to serve as a juror, you cannot work. And you won't be able to go to your work. Okay, that's what I'm trying to get to. Okay, so for you, it's a loss of income issue. Thank you. Last row. Juror 70 on the end over here. Yes, ma'am. Juror 74. so, the wedding is here,
Yes.
and when is it? Well, that's a Saturday, so this won't interfere with your ability to attend on the Saturday.
No, but
All right, thank you. Is there anyone that I've not talked with that would have a undue or severe hardship if asked to serve as a juror in this case for 6 weeks? I can call on you, you said now. 32? Yes, sir.
You did, but I guess it'd be a loss of income after hearing some of the other, it'd be a loss of income. I work nights with a post office.
I want you to check with your employer over the noon hour. And the reason why I say that is, as I've said, this isn't my first long trial. And I've had employees from the post office before, and at least at that point in time, they were paid for their jury service for the entire time. So I want you to check, because it's possible that that has changed, but at least at the last time that I did this, that was the case. Okay. Anyone, okay. Juror 35 on the end over here. Yes, sir.
Financial hardship. The length of trial that he- Last year, I just went back to work.
What kind of work do you do? Here? Oh, all right, okay, oh. All right. I probably shouldn't have asked that question of whether it was here. But yeah, okay, all right. And I thought I saw another hand. I've already spoken with juror 25. Juror 17.
Self-employed as well, and that would be no income.
What kind of work do you do? Okay. Is there anyone else? Let's see. No, I see you there. I'm just trying to make sure I have the right number, so just hold on. Juror 59. That is you, yeah.
I just wanted to add that.
Okay. Juror number 1.
Well, I'm studying for MCAT, and if I don't study 2 hours every day, my exam's coming up in May.
When are your MCATs?
May.
What time? The beginning or end? I'm sorry?
I haven't picked the date yet.
Okay.
but
Anyone else? No? I've got everything. Got everything. Okay. All right. Let me make sure. Yes, I do. Okay. All right. Let me also, at this time, I need to go through a list of questions which would disqualify you, and you should raise your hand if any of these apply to you. Are any of you related to the defendant or any of the attorneys? Anybody think they fit in that category? No response. Do any of you have a relationship of guardian and ward, employer and employee, landlord and tenant, debtor and creditor, or principal and agent to, or are you a member of the household of, or a partner in business with, or surety on any bond or obligation for the defendant? We're essentially looking for certain legal relationships with the defendant. Does anyone think they fit in that category? No response. Are you now or have you ever been a party in a civil lawsuit involving the defendant or have complained against or been accused by her in a criminal prosecution? Anyone think they're in that category? No response. Were any of you a witness to the matter related to the crime or its prosecution? Do any of you believe that you would be a witness in this case? No response. Do any of you have a personal or financial interest in the outcome of this case? No response. Are any of you a public law, easy for me to say. Are any of you an employee of any public law enforcement agency or the public defender's office? And juror number 3, yes, sir.
Deputy U.S. Marshal.
Okay. We're going to excuse you at this time. Thank you, sir. And you don't have to report back to the jury assembly room or anything like that. You can just go on about your business. Thank you. Anyone else? All right, let's have everybody turn off their cell phones if they would, please. Okay, all right. Do any of you have any feelings or a bias for or against the defendant or the prosecution in that category? Looks like we have a couple of hands. I'll go through those one at a time. Juror number 14, yes, sir.
As a father to young children, I have an emotional bias against the defendant.
Okay. Oh. Thought I saw another hand over. Okay, there we go. Juror 17.
Fine to hear everybody from the neighbor.
Okay. I want you to hold on to that thought because we have a different question later about publicity and things that you may have heard regardless of source. And it sounds like that may be what you're talking about. Is that fair? Okay. Anyone else in this group? No. Anyone in this group back here? Let's. Juror number 38. Yes, ma'am. Okay. I missed the first part. You have what? Children? Young children. Okay. Jury 39, did you have your hand? Yes, ma'am. Jury 39?
Not sure if this is where it fits. Yes, I worked as a children's. Child abuse.
Okay. No, I appreciate you bringing that up, and this is the place to bring that up. So this is more of, you don't know anything specific about this case, but because this case involves a child victim, that's what you're thinking about. Is that fair?
Yes.
Okay. Anyone else in that second row? And in the last row, juror 49. Okay. And I don't want to make that worse, but I do need to inquire a little bit. Is it, being in here with everyone, is it the facts of this case? Do you know something specific about this case? Okay. And anyone else in the back row? Front row over here. Juror 29. Yes, ma'am.
Very set my opinion on.
Said you're emotionally biased against what? And what is that based on? The publicity? Okay. And we'll get to that in just a moment. Okay. Juror 30, did you have your hand up, sir? Yes, sir. That's okay. There's no right or wrong answers here. Anyone else in the front row? Juror 32.
Same as others. I have 4 smaller children that may have been.
And juror 33, I think now might be the time to talk about the concerns that you had raised earlier. Tell me about those.
I was arrested in a public parking lot. My blood sugar was high and my diabetes was high. So they had an ambulance come out and they tested it. They said they're high, you can't drive. So they told me to walk off the premises. They didn't give me the address where the premises ended. So I started coming back and the police come back. Another ambulance comes back. Then they do the same thing, but this time they throw me on a gurney. Hospital. Next 3 days, I'm at psych. I had to pay $2,000 for this. There's nothing wrong.
Okay. And when did that occur?
About 3 years ago.
Okay.
But this is why I am extremely mad at the police department. No reason. I have to do this.
Okay.
This is why I owe this county nothing.
Okay.
I had to pay it.
All right. Is there anyone else in the front row? No. Second row. And let's see. Juror 44. Yes, ma'am. We'll talk about that in just a little bit because I have some things to tell you about that. So keep that in your mind because we're going to come back to that. We're going to circle back around to that. Okay. Juror 35. Yes, sir. All right. And I'm sorry, that's actually juror 45, not 35. Anyone else in that second row? Third row? Let's start with juror number 60 over here. I'm sorry, 61. Yes, ma'am. No, 61 right there. Yep, in the beige. All right, and juror 62, or yes, juror 62. Okay, I want you to hold on to that thought because we're going to get into that a little bit later. This is a slightly different, but I want you to hold on to that thought, okay? And in the row behind, the third row back, no, I know that. Third row back, anyone in the third row? Or I'm sorry, fourth row, anyone in the fourth row? Okay. On the juror 69, okay. Anyone else in the fourth row? And juror 74, okay. All right, thank you. Please raise your hand if you are not a citizen of the United States, are not at least 18 years old, nor a resident of this county. Anyone think they fit in that category? Please raise your hand if you are unable to read, speak, or understand the English language. Anyone think they're in that category? Please raise your hand if you are incapable due to physical or mental limitations to render satisfactory jury service. One think they're in that category. Hold on. Juror number 4. The mental ones, I'll do my best, and it's not going to help you. And no, I mean it's not going to help you because the explanation isn't very good. The physical ones are fairly easy. We've had some gentlemen or some people that have come through that have just had a surgical procedure, and they have to be near a bathroom, and they have to be able to take frequent breaks, those kinds of things. So that's kind of what we're looking for. The mental ones are less frequent, largely because it has to deal with sometimes people are on medications as a result of surgery. So they're having to take a course of medication beforehand, or sometimes they're having to take a course of medication before they start a particular treatment. And that medication affects their ability to be able to follow through, understand, and those kinds of things. There's not a real good definition for it, so I'm not sure I'm real helpful on that. Is there something that you had in mind?
I suffered from
That's something that we want to know about. It's not quite in this category, but that is something that we do want to know about. So I'm glad that you brought it up, and I'm glad that you're letting us know. Okay? Anyone else? Juror 49. No, but it's something that we need to know about because it's a little bit different. Okay? What we're talking about is something that really just prevents you from being able to do it entirely. So it's a little bit different. Juror 41. Yes, ma'am. Okay. Okay. Well, I'm glad you brought that up. I've had parties and people in the back who have had social or who have had seizure issues. So I'm glad that you let us know about that so that we know that potentially that might be out there. Is there anything specific that we can do to help you if that occurs? Okay. Okay. I have had parties and other people come into the courtroom with a service dog that helped them with seizures. Do you have a service animal? Okay. All right. Um, I understand. I understand. It's every issue. I understand. Same thing. I understand. It's every issue. Um, so I understand. Um, let's see. Is there anyone aside from juror 24 and 59 that I missed? All right. Um, let's see. Please raise your hand if you have the sole responsibility for the daily care of a permanently disabled person living in your household such that your service would create a substantial risk of injury to the health of that disabled person. No response. Please raise your hand if you have served for 5 days or more as a trial or grand juror in any state or federal court within the past 12 months. Has anyone been on a jury in the last 12 months? No response? All right. Give me just a minute. All right. What we're going to do is take about a 15-minute recess at this point. And again, don't discuss the case with anyone else. Don't discuss the case among yourselves. When we come back, I will be excusing a number of you, and then we will go from there. So all rise for the jury, please. Oh, you can go ahead and leave. It's all right. Sorry. Oh, wait. Before you go, before everybody moves, make sure that you know where you're sitting. We honor the third grade seating chart here. Causes all kinds of consternation if you come back and sit in somebody else's seat. So with that, go ahead and step out in the hallway. Thank you.
Or by the microphone.
Yeah, there you go.
Mm. It's always hit and miss if he's going to talk during this time period. So he's not muted yet. They wait until the jurors are out, and sometimes he talks to the counsel and sometimes he doesn't. He seriously better not be getting sick. That'd be so awful. He's been clearing his throat more and more each day. Let me see here.
Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Sixteen. Oops, forgot about him. So, six.
In the bushes.
Can you hear me?
I can, and I don't hear any crackling.
Really?
No crackling. Sounds good.
Yay. Okay. We'll
All
see you at
right.
lunch.
All right. See you at lunchtime. Bye. Sorry, guys. We had to do a quick mic test because she's been trying to join during lunch. Today's going to be particularly important because I'm going to need assistance during lunch today, and so I'm glad she's got her mic working and things like that. But mm, mhm. This is honestly the smoothest I've seen this go. I mean, we are only 49 minutes in, and we're already very well on our way to having the whole first section done.
Six.
Yeah, absolutely, Emily. Just want to give a shout out to all who are here to expand their world of true crime by becoming educated in the system. It's honestly amazing. It's interesting, I guess, to hear the actual process of how they do this and why they do this. You know, he's going for a pool of 110. He told us yesterday that each attorney will basically be able to deselect 16 each. So that's 32 that they'll be able to get rid of right off the
Okay.
top. But he said 110
You guys
because
got your
if they
seating
pass,
charts?
don't come back.
All right. These are the ones I'm going to excuse. Juror 1, 3, 5, 6, 9, 13, 15, 17, 19, 24, 26, 27, 30, 31, 33, 35, 36, 37, 46, 48, 49, 54, 55, 56, 59, 60, 61, 62, 63, 65, 67, 69, 70, and 74. Make a note to myself. Juror 32. Stauch, do you need a break or are you gonna be okay for a little while? You'll be okay? Okay.
I need like a pen so that I can point at the numbers on my screen so I can count right. No, I listed the number up above, Lady R, so you don't have to rewind. I always type up all the numbers as he's saying them so that we have a list of who's gone. And I missed the number of the 2 that he eliminated for police and military. So I don't know their numbers or what their numbers would have been, but they are up there. I have them on the screen right now, but I can't count whenever numbers are close together because of my dyslexia. Like my eyes like just don't want to cooperate. So I have to like point and count. I'm trying to do it, but the chat keeps moving, so I popped it up on the screen. Letecia is in the room with Vanessa, so it's possible.
Are you doing okay, Jess?
But 36 right off the bat, that's actually a good thing. He'll probably get us out of here. I'm wondering if they'll even make it to lunch break. I mean, I'm sure they'll still do one, but I wonder if he tries to get them out of
Mr.
here
Allen, have you gotten
early
any
'cause it's
word yet
Friday.
about whether or not your office can hear you? Yeah, just, yeah, we've got all of them off on both, yeah. Right, so that, no, this is a good way to do it. So we should, hopefully that will resolve that issue. Right, right. Yeah. You know, and that's, yeah, it is. Yeah. Well, I think there are good uses for it, but it's one more thing that the judge has to keep track of. And when they were talking about, I think that bill is still in front of the legislature. I think there were, I don't know if it was courtrooms or courthouses, but there were about 100 of them in the state that had none, none at all. Right. So, um, right. Well, and the other thing that they don't think about was, the separation between state and county, because I had a problem in my courtroom a couple of weeks ago. Our technology was working fine, but the projector in the middle of from the ceiling is owned by the county and installed by the county. And so we could do everything that we could, but we don't have anything to do with that. And so we had to get both of them over here at the same time. And it just is, there are some logistical hurdles that I think are not being considered. But I have to say, I have done it. I actually did a virtual trial where I was the only one in the courtroom for about 8 days. It was weird the first time I took the bench, but
The whole thing was virtual?
yeah, I was the only one in the courtroom. It took a little getting used to, but it worked okay. Is it the podium should be turned off as well. We turned off the podium and all those microphones at council table. Oh, yes. What will happen when you get there is you have various options. all those cords that are now draped over the back, you can connect to a laptop. There's also a Elmo in the side of the podium. And so and there's also a connection similar to what you have at the table on the podium. So you just need to let me know because I have a preview screen up here. So when you get to that point, if you want to come in a little bit earlier or something like that and see how it works. Have you ever been in here and used it before? Okay. So if you want to try it out, just let us know and we can work that out. But it's really pretty easy. I can't count the number of times I've been in here and used it, so it works fine.
What I'm getting back is that they think.
Okay. We think we figured it out. Okay, let's go ahead and let the jurors back in. All rise for the jury, please.
They're probably all still walking in and getting seated, just so you guys know they're not muted, so it's just like a really long, awkward pause of silence. He's gonna come in, or they're all gonna come in, and he'll get rid of the 34 that they're deselecting.
So you're free to go about your business, continue on with whatever you want to do. So at this point in time, we're going to excuse juror number 1.
I heard him like reading numbers very briefly, but he must be towards the back of the room, like away from his microphone, which I hate how they're doing the microphone system, and I hope it doesn't affect us during the trial. Mike Allen is on the prosecution side. He's the district attorney. This is Mike Allen. And William Cook is this other man here. We heard Mike Allen yesterday, so we will likely hear William Cook today from the prosecution. And yesterday we heard Tellini, so we will probably hear. Wait, William Cook is on the defense. I've said that wrong.
Right.
Tellini and William Cook are on defense.
Right. At this point in time, I'm going to give the attorneys an opportunity to give sort of a 2-minute, and it really is only 2 minutes, mini opening statement. It's just an opportunity for them to tell you what they think the issues in the case are. It's not necessarily what you'll find them to be if you were selected to serve as jurors in this case. With that, prosecution.
Dan Stauch by his stepmother. Being murdered by a series of choices and decisions accomplishing that. Chose first a knife, stabbed him 18 times. He fought for his life. He has cuts on his arms and his hands. Trying to chose to use a blunt force object, smash his head in, fracturing his skull. Then she chose to get a gun, a handgun. Fire that gun 3 times, striking him in his chin. Then she made the decision to clean up the crime scene. Then she made the decision to come up with several different versions of what actually happened. Starting with, Gannon just ran away. I don't know where he's at. He was supposed to be in a friend's house. To, I got sexually assaulted. Someone took Gannon in a suitcase. That suitcase was another decision she made. Stuffed Gannon in a suitcase after she stuffed him in a suitcase and made a decision, tied the body up in Palmer Lake.
Wrap up.
Then she made a decision to get the body and drive it to Florida, throw it over a bridge.
All right. Mr. Tellini.
Blood slather that all over, all. Dr. Dorothy. Diagnosed her. Dr. Lewis.
Council approach, please.
I really hope that they're gonna redo this because that was very
Sure,
long.
we're gonna excuse you.
Uh-oh, somebody's in trouble. Why'd they get excused like that?
All right, I want to read some instructions for you. These are, you'll get some similar instructions at the end of the case if you're selected to serve as a juror in this case, but I think it will inform our discussion going forward. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all of the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. A few minutes ago, you heard me tell you that the defendant was presumed to be innocent. That means that if I were to give you a verdict form right now and ask you to fill it out, the law would require that you find the defendant not guilty. And the reason for that is she is presumed to be innocent and no evidence has been presented in this case, none. Nothing that the attorneys say ever is evidence. The only evidence in a case comes from a witness who raises their hand, swears to tell the truth, and takes the witness stand. You may also see physical evidence, such as photographs, diagrams, charts, those sorts of things. But you will never see the attorneys in this case take an oath to tell the truth and take the witness stand. They are paid advocates. Their job is to convince you of a particular position, whatever that position is. But that's not any different than any other case. In any civil case, in any divorce case, in any criminal case, the job of the attorneys is to convince you about a particular position that the evidence either does or doesn't show. So this case isn't any different than any of those. So the fact that the attorneys told you what they think that the issues in the case are doesn't change the presumption of innocence here. Ms. Stauch is still presumed innocent, and if I gave you a verdict form right now, the law would require you to fill it out as not guilty. In addition, you may think, or someone may ask you whether or not the defendant has done something wrong, or else she wouldn't be here. However, that's an improper question. We don't just randomly select people from the street to suddenly appear in the courtroom as a defendant in a case. Obviously, there is a process in place which resulted in the filing of charges against this defendant. However, the charges against the defendant are not evidence either. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. As such, the defendant is presumed to be innocent, and until the district attorney presents sufficient evidence to overcome that presumption beyond a reasonable doubt, you must continue to presume the defendant is innocent. Unless and until the prosecution presents sufficient evidence to overcome the presumption of innocence beyond a reasonable doubt, Ms. Stauch's guilt has not been proven. You may also find it useful to think of the charges in this case as similar to a recipe from a cookbook. When you actually see the charges, they'll have different elements to them, sort of like ingredients. Now, I want you to think, for instance, if you wanted to make a Denver omelet and you took some eggs and you scrambled them up and you added some ham and you added some cheese and you added some mushrooms. You might have a really nice ham and cheese omelet, but you wouldn't have a Denver omelet. If the prosecution charges the defendant with a Denver omelet, that's what they have to prove. They have to prove what they've charged and not something else. I also want to talk about the defendant's right to remain silent for a moment. Someone may ask you whether or not you would need to hear from both sides in order to be fair. Everyone wants to be fair, right? Everyone wants to hear both sides. But that is not the process that we follow in a court of law. This isn't the Maury Povich or Jerry Springer show. The government brought these charges against an individual. Because of that, the government has the burden of proving beyond a reasonable doubt every element of the charges that it brought. The defendant has no obligation to disprove the government's case. Stated differently, the defendant does not have to produce any evidence or any testimony. In fact, defense counsel could take a nap at counsel table, could play cards. I suspect neither one of those are going to happen, but that would not change the prosecution's obligation to prove every element of the charges beyond a reasonable doubt. In addition, every defendant has the constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. That is because it is not evidence, does not prove anything, and must not be considered for any purpose. Sometimes the attorneys will ask a question sort of designed to elicit a response from someone such as, well, I know if I were accused of a crime, especially one like this, I would take that stand and I would talk until the cows come home to make sure that everybody knew that I was innocent. As I indicated earlier, that's kind of a trick question because that's not the process that we follow in a court proceeding. In any event, does anybody here know what the number one psychological fear in the population is? It's greater than a fear of death and greater than a fear of meeting up with a rattlesnake on a hiking trail. Anybody know? Public speaking. So naturally, the process is that we bring all of you strangers into a big room with a whole bunch of other strangers and ask you questions and ask you to start talking in front of other people. I want you to think back on that experience. Were you nervous? Were you thinking, gee, did I understand the question right? If you had a choice, would you have chosen not to be questioned? And none of you were questioned in front of a jury by these attorneys regarding facts, and none of you either witnessed or had been accused of a crime in this case. The bottom line is that it is possible that the defendant won't testify. And it's possible that she will. But regardless of who testifies and who doesn't, regardless of whether you want to hear something more from someone or not, the real question you have to decide at the end of the day is always the same. And that is, based on the evidence presented, whatever that evidence is, has the prosecution proven beyond a reasonable doubt that the defendant is guilty of the crime charged? Is there anyone here who thinks that they cannot give Ms. Stauch the presumption of innocence to which she is entitled? Please raise your hand. All right. Looks like, let me start in the back there. And see, now that we've excused some, I have a harder time figuring out which row you're in exactly. So let's see, juror 38. Yes, ma'am. And how long have you done that? Okay. I think we're going to get to that in that's a little bit separate. My question is, and we're going to ask here in just a few minutes, we're going to have, my staff is going to pass out a list some sheets with some names on it. And the question that I'm going to have is, do you know any of the people and do you have any witnesses, or do you know any of the witnesses in this case? So wait until we get there. My question is, can you give Letecia Stauch the presumption of innocence to which she's entitled under the law? Okay. And is that based on your contacts with the teacher? Is it based on something else? What's it based on? All right. Anyone else in that row? No. I thought I saw hands in the back row. Okay. Juror 51, yes, ma'am. In the black sweater, yes, ma'am.
Teacher in elementary.
All I know is children are. Happened to them.
What grades did you teach? Okay. All right. And juror 51, did you have your hand up? Yes, ma'am. Okay. And just for purposes of the record, I think I erroneously referred to her as juror 51. That was actually juror 52 that just spoke. One over here. And juror 29, this is the time to tell us what you had on your mind earlier. Yes.
And
No, it's okay. It's all right. This is a tough case, and it's not a case for everybody. I mean, we have this all the time. I preside also over sex assault on children cases. Nobody is going to say that this is a good thing that happened to anybody. Okay. I think what I'm going to do right now is excuse you. So juror 29, you're excused with a thanks to the court, okay? Anyone else in this front row? Second row? Third row? Fourth row? Yes, sir. Juror 68, yes, sir. Let me see if I can help you with that, because you are not the first juror in this case or any case that has struggled with that. Okay. And so let me see if I can help you out a little bit. Every defendant, doesn't matter what the case is, every defendant in a criminal case is presumed to be innocent. The prosecution has to bring evidence to establish the guilt of the defendant beyond a reasonable doubt. With me so far? Okay. So this case isn't any different than any other case in that regard. Ms. Stauch has the right to require the prosecution to prove the elements of the charge against her. And you have to start in with saying, I don't know anything about this case. No evidence has been presented. She's entitled to a presumption of innocence. Can you do that? Okay. And what is it that is holding you up? Okay. Okay. So it is more the personal experience. It's not necessarily, it's not necessarily how the evidence shakes out in this case, as it is that you have children that are young and grandchildren that are young. Am I close? Okay. All right. Okay. And, you understand that, I'll tell you, I've been doing this for a long time. And I will tell you that I don't think I've ever had an attorney lie to me. But attorneys do have a particular point that they're trying to persuade jurors for. In addition, just like you and I, when we see something, because of our own backgrounds, we sort of see it a little bit differently, even though we could be standing in the same spot, right? So they have their own viewpoints, and they will see evidence. We sometimes have things where the attorneys say, well, this is what this witness is going to say. And then you hear the witness and you go, wait a minute, that's not what I heard. I heard something completely different. And I don't think the attorney was being dishonest. It was just the attorney was thinking, this is how I see it as it fits in and in my role of advocacy and those kinds of things. Does that make sense to you? Okay. So the issue is, can you give Ms. Stauch the presumption of innocence and listen to what comes from the witnesses on the witness stand? I didn't hear that last part of it.
Like what you explained to me, possibly.
Okay. Be hard for you though? Okay. All right. And was there anybody else in that row? Back row, juror 72. Yes, ma'am.
For me personally, it's just I read the affidavit that was media.
Okay. And we're going to get into that separately. Let me have you hold on to that thought because we're going to get into the publicity. Because that's a little bit different. So my question is, we'll come back to that when I get to the publicity, okay? Don't let me skip you, all right? Okay. All right. Let's wade right into that now because I think it's probably a good point for it. Have any of you heard anything about this case from any source, including friends, family, the news, other media, or the internet? Just about everybody that's left. Okay. All right. In this case, you will be asked to render a decision based on the evidence presented in this courtroom and the instructions that I give you. Even if you have heard or read something in the media, the real question is whether you can put that aside and decide this case based on the evidence you hear in the courtroom. Is there anyone who thinks they cannot do that? Starting over here, juror 14? Yes, sir.
I just feel like it's already made up. It's gonna be hard to. Or something like that.
And is there a story or information that you're thinking about particularly?
Not really. I mean, aside from emotional bias, I'm a father to young children, so there's that side of things. But following the story for so long, you kind of create your own narrative of how it went down.
And
It's very hard to convince me otherwise of how I already strongly feel about this case.
and how long have you been following the story?
Since the beginning, my parents live in the same community.
Okay. Did you ever go over to that community while the searches and those things were going on? Okay. Anyone else in this group? No? Over here? Anyone? Juror 51? Yes, ma'am. Okay. And okay. Anyone else in this group over here? And let's anyone else here aside from juror 72? Juror 72, what's on your mind?
About reading the news, started reading about.
Okay, all right. So you do not believe that you could give Ms. Stauch a presumption of innocence? 72? Well, that's what threw me off. Okay. For 45, did you have your hand up, sir?
Yeah.
Yes, sir.
Question about like, what is an opinion or had rationally set that aside, or is it about being like I could possibly say that I have some
You know, that's a great question. And here's the best answer that I can give. The prosecution is going to have to prove everything that they're required to prove beyond a reasonable doubt. The defendant is presumed innocent. That's where you have to start from, okay? So the question, and let me start there. Can you give Ms. Stauch the presumption of innocence to which she's entitled? Okay. So then what we look at is the prosecution has to prove everything beyond a reasonable doubt. And as I said, there's certain things that they have to prove. The paragraph number 1 in every criminal case reads the same. In the state of Colorado, on or about the date and place charged. That's essentially what it reads. And then it changes after that, depending on what the crime is that's charged. They have to prove all of that. So you may have in the back of your mind saying, oh, you know, I read about this, or I read, and you'll hear it from the attorneys that there are 2 different opinions here. You will have, I read in the paper that there was one doctor that said this, and I read in the paper that there was another doctor that may have said this. Okay. So you read that in the paper. Okay. Well, I can tell you that you're probably going to hear from those doctors. Or I suppose it's possible, incredibly unlikely, but possible, that you don't hear from either one of those doctors. And then you have to say, okay, I have some information from the newspaper. There was no witness on the witness stand that said anything about that. Would you be able just to say, I can ignore that and just decide it based on what information I get from the witness stand? Does that answer your question? Okay. It's not that you have to unhear it or unsee it, right? Because we can't do that. So the question is, you have to decide it based on what you hear in the courtroom, not on what somebody else says about something else. Does that make sense? Do you think you can do that?
I guess it's like, so
Right. Right. And what you have to do is just say, okay, that's something that I heard in the paper. I just need to ignore that part. I just need to decide the case based on what somebody has said from the witness stand. Do you think that you can do that? Do you want to think about it for a little bit? Okay, no, that's a fair answer. Okay. Is there anyone else that I've not talked to about that issue that wants to say something? No response. All right. At this point in time, what I'm going to do is I'm going to have Mr. Combs and Mr. Sproul hand out some witness lists. And the question that I'm going to have for you at the end is, do any of you know any of the potential witnesses in this case? I will in a minute. I think we have one that's still working on the witness list. I was waiting until they got done with that first.
Think they're gonna read the witness thing, and then they will do the final cut before lunch typically. So, I'm thinking that probably within the next 15 to 20 minutes, we'll probably be at lunch and we'll start going through the arrest affidavit again.
Right, and
So
are we all done? One juror just left yet. Have you finished with the witness list, sir? Oh, all right. Are there any other witnesses that either side anticipates calling that are not on the, or that may be a witness that are not on the witness list? Prosecution,
Hang on, thanks.
defense?
Possibly Dr. Ron and even possibly keep it correct.
Does anybody think they know any of the potential witnesses in this case? Mr. Luther? Or I'm sorry, juror 47? Yes, sir. Sorry. Okay. Is there anything about that that you think would cause you any difficulty serving as a juror in this case? Okay. And you said that you retired how long ago? Okay. All right. Anyone else? No? All right. Now that we've narrowed down the group significantly, I want everyone to look around the courtroom. And the question that I have for you is, do any of the potential jurors know each other? All right. Okay. I was worried for a minute because I only saw one hand, but now I see two. So, okay. All right. Juror number 7, who do you know? Okay. And you're referring to juror 14? Okay. If you were selected to serve as a juror and juror 14 were also selected to serve as a juror, would you have any difficulty with that? Would you be able to express your opinions even if they disagreed with those of juror 14? And juror 14, let me ask you the same questions. If you were selected to serve as a juror and juror 7 were also selected to serve as a juror, would you have any difficulty with that? And would you be able to express your opinions even if they disagreed with juror 7's? Okay. Anyone else? No. All right. Okay. Does anyone or do any of the potential jurors know either myself or a member of my staff? No response. Is there anything about the nature of this case which would, in and of itself, influence any of you at arriving at a verdict? No response. And I wanted to let you know that if you are selected to serve as a juror in this case, you will only be deciding the facts of this case. In Colorado, now in Colorado, the jurors never decide a sentence. The only time that they did that was when Colorado had the death penalty. This is not a death penalty case. So you only decide the facts of whether or not the prosecution has proven beyond a reasonable doubt everything that it's required to prove. You won't have to decide a sentence if that becomes necessary. Is there anything about hardship or about publicity that anybody wants to tell me that they've not already told me? Juror 38, yes, ma'am. So in the afternoons, okay. Anyone else? Juror 21. Okay. Okay, and that's what I was going to ask. And we understand that people are putting their lives on hold to a certain extent. We also understand that time goes on, and we also understand that things happen in people's lives. So I appreciate you bringing that to our attention. That's one of the reasons why we select more than 12 jurors, because it's possible that something may occur. And if you are selected to serve as a juror, and if something like that happens, we can deal with that. Okay, but I'm glad that you brought it to our attention. Anyone else? All right, no response. We have just a moment. Okay. At this point in time, I'm going to excuse juror 14 here in the front. Juror 38. Juror 51, back row there. Yes, ma'am. And juror 52 right next to her. Juror 68, black shirt. Yes, that's you. Yep. Juror 68 and juror 72.
Not sure though, Rexy, because they were down to 27, if you remember yesterday. and they were still able to get 21. So
Juror number
they may be
41,
okay.
how are you doing? Yes. Okay. And do you, when you start to have a seizure, do you notice anything before it happens? Okay. Are you still able to communicate when that happens? Okay. And do you have any feelings like that now? Okay. But so far you're doing okay? Okay. Council approach, please.
So he'll be muted for a second while the council approaches. Have a good day at work, Hawaiian Mama. And those of you guys who are listening at work, thank you so much for being here and listening to Justice for Gannon. I love that so many people care about this jury selection and this case. It's just absolutely amazing how many people are so invested. He really did touch all of our lives.
All right, ladies and gentlemen, what we're going to do is take a lunch recess, and I know that it's early. This is our fourth day. Thank you. It's our fourth day in doing this. We're getting a little bit faster every day. And here's what I'll tell you what we're going to do. Over the lunch hour, the attorneys and I will be looking at your questionnaires, and so that we have a little bit better feel of some background and some questions to ask and things like that. So we're going to be using our time to look through some questionnaires while you are having lunch. Most of the eating joints are north on Tejon. There are a few south on Tejon as well. There's a bistro that's in the basement. Is it open today? We got an email. I think it's closing early. It's closing early. You should be okay. We're leaving, or you're getting out of here early enough that you should be okay to go to the bistro if you want to do that. Here's what you can do over the lunch hour. You probably will have somebody, a spouse, significant other, somebody who's generally interested in your welfare, wondering what's going on with you. You can tell them that you are in the midst of jury selection. You can tell them it's on this case. You can tell them that if you are selected to serve as a juror, you will come back on April 3, and there will be further questioning of you at that point in time. And you can tell them that if you are selected to serve as a juror, that you will start April 3 and the case will go for approximately 6 weeks. They will ask you more. They may try to give you opinions about things. And here's what you need to do. The judge said, I can't talk to you about it anymore. Those are the only things that I can tell you. You have to decide the issues in this case based only on the evidence that's presented in this courtroom. We've already talked about what evidence is and what evidence is not. So have those people help you, because you're going to have to avoid news exposure. You're going to have to avoid exposure from opinions from friends. And so have those people help you and say, look, I can't talk to you about it. Help me avoid that stuff. If you hear something on the news, change the station. If you read something in the paper, flip the page. Just don't read the story and just flip the page. If someone wants to share their opinion with you, say, I can't do that. The judge said, I can't. That puts the burden on me, not on you. I'm married to a woman who has a lot of really strong opinions. And she's happy to share those with me pretty much whether I want her to or not. And I know that when I go home today, she's going to ask me how my day went. I'll tell her once we get into evidence, she would ask me how those days went. And she would say, well, what did the witnesses have to say? And I'd start to tell her. And at some point, she would look at me and she would say, Well, you didn't really believe that, did you? And pretty soon I'm having a conversation about what I should and shouldn't believe with somebody who wasn't even here. You can't do that. If you are selected as a juror in this case, you can't even discuss the case among yourselves while it's going on. You have to wait until the very end. So the way to avoid that is just to say, the judge said, I can't talk to you about it. Because I know if I were to tell my wife, look, I'm just not talking to you about it, it would lead to an entirely different conversation. So this way, it puts the burden on me, not on you. And hopefully you can avoid all of those things that we're trying to avoid. If I can have everyone back in the hallway a little bit before 1 o'clock, we should be able to start on time at that point. Here's what you can expect. When we come back, the prosecution will have 45 minutes to ask you some questions. Then the defense will have 45 minutes to ask you some questions. We'll take another break and we will then strike some other people. Jury selection is actually a process of deselection. As you've noticed, there's not nearly as many of you now as there were when we started the day. So we will start deselecting some of those people. And then at the end of the day, we will have some qualified jurors to come back on April 3. At least that's the hope. So have a good lunch. Enjoy yourselves. Again, you can talk about anything, just not this case. So with that, all rise for the jury, please. Oh, and juror 32, talk to your supervisor, okay? During this time period. Okay. Well, you can just talk to somebody there so that we have some sort of answer, okay? Okay.
Wow, that's gonna be a long break. That's almost 2 hours. I was kind of hoping he would do a short break, like, or just an hour like he has been doing, about an hour and a half, but sounds like he is going to still go till 3, which is crazy. They could have let us go early today. Come on, judge, you could have snuck us out.
Thank you. May all be seated. Record should reflect the jurors have left the courtroom. So when we come back, we will start with Wadir and see where we are at that point in time. Is there anything else that we need to take up at this point in time? Prosecution? 1 o'clock. Defense? Make sure my request is that all the questionnaires for all of the questionnaires become part of the record. They're all going to be in there. And we haven't decided yet whether we're going to upload them by day so that the 75 are in that day, or whether what we're going to do is upload them by day of the people that we excused. And then when we get to the end of at the 113, load them up separately. But every questionnaire that has been submitted will be uploaded in some fashion. Yeah. No, and it's been down that road, been there, done that. So yes, all of them are going to be preserved and uploaded. They won't be accessible to you, but they'll all be uploaded. Yeah, okay. Sure, yeah. Okay. All right, court will be in recess then.
Hey, hey, hey.
Hello.
How's it going?
It's
Sorry, I'm
going
just
good.
quietly
He's
going on
just
because I don't
knocking
know
them
what.
out.
Yeah, he really is, and he straight up shut off the WebEx just now to he shut it off during the thing there. Whatchamacallit, the break here. I gotta switch my earbuds over real quick so that I can hear you
All right.
because I can't have them on while he's on because otherwise you can't hear the WebEx. So
All the sound issues.
yeah, 1 second. Okay, I think we got it. No, it keeps hooking up to my phone. Hold on. We will make this happen. Just gotta switch this setting. All right, we should be good to go now. So, you're gonna run an errand. Yes, that's okay. Yes, please stay listening. We are going to talk about the arrest affidavit more. We are on page 15. We started reading through it yesterday during lunch break. In the Bushes is joining me, you guys, because since this is such a long break, I mean, we're talking 2 hours. There is a pretty good chance at some point during this 2 hours that I will have a poopy diaper or something along those lines. And so she is up here to kind of help me, number one, talk, but fill the air too, in case I have to go take care of mom priorities. That always comes first. And I apologize if there are brief issues and lapse in conversation and things like that, but please bear with me. I always put my kids first before this channel, and I'm sure most of you guys understand that. So let me get the arrest affidavit. What do you think about today so far? Let's talk about that first.
I think he's kicking them.
Oh yeah, he is like rolling straight through. Cassie, welcome. Thank you, Emily Flotilla, for gifting another membership. And Cassie, welcome to the Sleuth family. We are just growing a little bit each day, you guys. I love so much how much the gifted memberships are going out and stuff like that. It so helps the channel. I look forward to each of you guys considering joining us in Discord if you have that. If you don't have Discord, that is fine. There's also the Facebook page that you can come join us in. And I can't remember what I was going to say next. But I love watching our sleuth family grow a little bit each day. We're actually almost to 100 members because of how generous people have been gifting memberships. I think we're 2 away from 100 members. And so that's astronomical. I've hit 50 or 60 before, but I've never hit 100. And so I love you guys so much that have been contributing to the page and helping to do that with the gifted memberships and with people who are joining. That helps too. I know that some of you guys have probably seen the Battissimo drop the link about the computer and stuff like that. I am buying a new desktop, a new tower, and I've never asked really for contributions or anything like that. That's really not, I don't do it. Like if people super chat and if people join and things like that, I so appreciate it, but I've never been one to ask for assistance and stuff. But really what's happening is I upgraded my internet because we had been having issues with buffering and different things like that. And for whatever reason, it still didn't help stream any better. And so whenever I was looking into it deeper, the issue is my RAM and my processor. And we attempted to up that and just buy the things to make it go smoother inside of the tower. I don't know. I just agree with my husband, and he bought things that he thought would help. But since I have a desktop mini, like a tower mini, he said, there is a limit on what I can put inside of it, I guess, without spending astronomical amounts of money. And so whenever it came down to it, it was a lot cheaper for me to switch over and um and just upgrade the desktop itself. It's cheaper to do that than it is to buy the things that fit inside of the mini hard drives, if that makes sense. And so I'm looking at a situation where I'm going to have to switch everything over onto a new computer and things like that and purchase a new computer. But I did find one that's refurbished that they told me should work for what we need it to do. And it's really not that bad. And so, it's just, you know. So you guys who are supporting the channel and stuff like that, I so appreciate it because it does help keep it so that I'm able to do this. But So, oh, thank you so much, Emily. I appreciate that. So in the bushes, like I said, I love how fast the judge is going today, right? It seems like, oh, look, there's actually 2 different people who sent cash apps. Thank you so much, you guys. I didn't even check this.
Oh, thank you. I've been
Yeah.
grifting all day. Thank you, guys.
Listen to you. You are crackling again. Are you using that headset you had earlier?
No, let me turn down and see
Nope, it's your
if
internet.
that
Tell now.
helps.
It must be your connection. You might have to go out to the squirrel garage, raccoon garage, wherever it is.
I'm in the garage. I'm
Oh, are
directly
you?
under my Wi-Fi. Yeah,
Oh, that's
I
great.
ran away from the dogs so they wouldn't interrupt our thing today.
Mhm.
Because if y'all hadn't figured
Thank you
out,
so
I
much,
got some
guys.
loud dogs.
Yeah.
Because my
Yeah, they
house is
do. They
wild
keep
kingdom.
adding so much bloatware to the electronics, it's exasperating. And that's what my thing was, like, whenever I first started streaming, whenever I hardlined, it was fine. I mean, I've been doing this for we're going on 2 years almost now, and I didn't understand how just out of nowhere it seemed like that it all of a sudden it wasn't okay. And like I said, I upgraded us to we're in Wi-Fi 6 now. I bought booster things to go over the house. I like I said, we're hardlined and I don't know what to do. And that's whenever I found out, like, apparently I just need more RAM and all the things. So, but sorry. Okay, so I'm going to go ahead and start reading the affidavit. We were on page 15. Let me get this shared for you guys and pulled up and all the things here. Okay, so we were talking about the areas that they had found blood. And so they found blood in the hallway leading to the utility room from his bedroom, the utility room itself, the staircase, the landing leading upstairs from the utility room, the pathway to the garage from the stairs, the garage itself. In all of these areas, investigators found positive results for the likely presence of blood. And so this was no small amount of blood and things. This was, a lot of blood. Specifically in Gannon's bedroom, in the corner of the room, investigators located an area where suspected blood had seeped through the carpet, through the pad, and stained the concrete. Furthermore, there was also blood stains and projected blood splatter located on the walls in this area. Indeed, over 50 droplets of suspected blood were found on the walls near Gannon's bed. Crime scene investigators also suspected someone attempted to clean the walls based on the way that Blue Star reagent reacted on the wall. Gannon's mattress was also seized and contains a red stain consistent with blood in the same area as the stain on the carpet. The blood cast off on the walls, the stains on the mattress were swabbed, but were not tested with Blue Star reagent. The laboratory results have not yet been returned, but because other blood in the area was determined to be Gannon's blood, investigators suspect the blood in the mattress is also Gannon's blood. I have included several crime scene photos that include the wall next to Gannon's bed, the carpet pad that was also removed by investigators to expose the concrete below. Based on the orientation of Gannon's bed, the vast majority of blood would be in line with the position of his head and torso, and consistent with the stain of the mattress displayed above. I submit that the blood located in Gannon's room appears to have been cleaned up based on residual blood residue on the baseboards and electrical outlet cover, the blood that soaked through the carpet. DNA laboratory testing has confirmed it was indeed Gannon's blood, and Gannon's body has not yet been found, reasonably indicating that this was likely the scene of Gannon's murder. Now, keep in mind, this was 4 days before T was arrested and almost 3 weeks before Gannon's remains were found. Investigators have requested but have not yet received a report from Tom Griffin, who is an International Association for Identification. I'm sorry if you guys can hear them. They're playing. They're having a great time, though. Certified senior crime scene analyst and bloodstain pattern analyst, and a crime scene reconstructionist. Mr. Griffin examined the blood spatter on Gannon's walls. Mr. Griffin preliminarily, a P word, reported that that the stains on the walls are consistent with one or more blood spatter producing events, which could include gunshot, blunt force trauma, or a stabbing. And we later found out after they located Gannon's remains that in fact it was all three of those. They found evidence on his body of a gunshot, of blunt force trauma, and of a stabbing, which is absolutely devastating. Mr. Griffin did not believe that the blood stains were aspirated blood, primarily due to the lack of air bubbles in the stains. Furthermore, the shape of the stains were affected by the surface texture of the drywall itself. The final report from Mr. Griffin has not yet been received and is pending peer review. Have a good night, Vanessa. I hope you get some rest. Okay. Trace evidence swabs of suspected blood were obtained from the electrical socket next to Gannon's bed. These swabs revealed the blood indeed was Gannon's blood based on DNA profile testing. The electrical socket also has evidence of streak marks, which are reasonably suspected to be from Letecia's attempt at cleaning. When investigators removed the outlet cover, a visible red stain was present, outlining the edges. The presence of this stain tends to support that there was enough blood around the outlet to seep around its edges, leaving a visible outline. And like all these pictures are in black and white, but it's just absolutely devastating to even think of the fact that there was that much blood that it seeped in around the cover and stuff like that. You know, she's a complete monster. But then whenever you sit there and think about that and think of the DID diagnosis, like how exactly are they intending to say that this fits at all? I just don't get it. I really don't. But again, they don't have to prove it. They just have to claim it. I'm pooping again. Okay. So in the bushes, if you could just chat for a moment about everything. We have a poopy diaper, which I figured we would because every time I'm live, this seems to be when she schedules it. So
Of course. Yeah, that is definitely a lot of blood. That was a very bloody crime scene. And she did a really poor job of cleaning it up, thank God. But if you look how big that spot is on the floor, it's just huge, and it had to go through a mattress, a box spring, the carpet, the pad to get to all that, get down to the concrete. It's heartbreaking. And it's going to be very, very hard for me to hear what isn't in the affidavit because things have changed. They've gathered more evidence. There's going to be a lot more to find out than what is in this affidavit. And it's going to be very hard to listen to what she did to that poor little boy. But it's 3 years coming. And I can't imagine being an investigator at the scene and finding all of this.
oh yeah. It would be so hard. It would be so hard.
You know they were freaked out.
My mind tries to wrap around the fact that we only have 32 pages and we have this much. They have 80,000 pages, I think they said at one point, right? Was it
Yeah,
80,000? Yeah.
it was astronomical.
I think she's having issues with her internet connection itself, BC. I don't think it's her phone placement.
Am I having
Sorry.
issues again?
Well, it's slightly staticky. It's nowhere near as bad as it was yesterday.
We're having severe storms here today.
Mhm.
It's not
I
raining
totally get
now,
it.
but it's nasty overcast and it's not done. It's going to be coming in waves all day and all night
Right.
with tornadoes.
Oh boy.
Yeah.
Okay. So yeah, Emily, I am too. I'm sure there will be moments that I want to look away or I don't want to hear it, but at the same time, his family is going to be sitting in this courtroom listening and hearing all of this stuff. Gannon went through it. He suffered through all of this and it feels like I have to know. I have to know so that I can understand what he had to go through. And I know that sounds weird, but at the same time, like, if he had to suffer through it, the least I can do is be there and listen and be there for the justice side of things. Yeah, it's definitely going to blow our minds on what's still to come and hear about, for sure. For sure. True, Boo will. Also, when they found him in Florida, how quick they knew it was him. Such a high profile case. Many bizarre twists and turns and the horrific tragedy for Gannon and his loved ones. I'm sure it probably had something to do with the suitcase. Also, the blankets found with him and his actual appearance. There was details about him that just told them right away that this could possibly be him. We have to remember they keep telling us that we're going to see pictures of which we may ourselves not see it. I'm not sure how the cameras are going to be facing and if we'll be able to see all of the evidence that they present. I don't know how that works with WebEx streaming and if we're going to get to witness it, but the people inside of the courtroom, they've already told us they're going to see photos of him after he was in this suitcase for 6 weeks. These jury members are going to see that, and they've warned them, each of them, the prosecution and the defense have warned them. They're going to see these photos. Okay, so back to this. It says, I have also included a photograph of the suspected blood stain in the concrete located in the corner of the bedroom where Gannon's bed was positioned. This stain is also visible in the photo depicting the suspected blood splatter on the walls. The carpet above the stain in the concrete was clean, and investigators suspect Letecia cleaned the area based on carpet fibers on scrub brushes, the acquisition of carpet cleaning supplies, vinegar, and baking soda. 6627 Mandan Drive was a new construction build, and the Stauch family was the only family to reside in this residence. So there was not going to be blood or things there prior to them moving in. On January 29th of 2020, investigators recovered a piece of carpet from the utility room with possible blood stains. The recovery of this carpet tends to further support positive alerts from the Blue Star reagent in the utility room. The Metro Crime Lab reported the substance tested presumptively positive for the presence of blood, but was unable to develop a DNA profile. On January 29, so 2 days, we're talking 2 days after she reported them missing, they found blood stains. They found the brushes in the dishwasher. It says they found found in the dishwasher multiple carpet brushes with suspected carpet fibers on them. The dishwasher appeared to have been run. Investigators believe these brushes were used to clean up the murder scene. To be clear, no formal testing was completed to confirm the fibers on the brushes were carpet. They found that 2 days 2 days, you guys. They knew right off the bat. That's why they started asking for Gannon's DNA. That's why they wanted his toothbrush. That's why they wanted DNA from Letecia, because they knew on January 29th, I believe without a shadow of a doubt, that she had done something to him. Investigators also located an empty gallon-sized container of vinegar within the residence. Mr. Stauch believed there was approximately half the container left before he left for Oklahoma on January 25th, 2020, as mentioned above. Additional vinegar was purchased on January 27th of 2020. EPSO deputies that responded to the Stauch home on January 27th did notice that blood stains in Gannon's bedroom, and it should be noted. They did not notice. So whenever they came that evening at 10 p.m., they did not notice that there was blood stains in his bedroom. And it should be noted the initial report was that Gannon had left home and had not returned. As additional information was developed and more forensic searches of Gannon's room were conducted, which revealed the aforementioned evidence. There were small traces of blood found in the depressions of the drywall and the paint texture that Letecia failed to remove when she cleaned the murder scene. She cleaned it quick. This all took place probably between 2:20 and 2:45. She did this act quick. She murdered him quick. And then she tried to clean up just as quick, and it did not work. She left a lot of evidence behind. I've received and viewed the Metro Crime Laboratory report, case number blah, completed by, a serologist, Sherry Holmes. Although I have discussed the results related to this DNA testing and other portions of this affidavit, the intention of this section is to provide clarity and eliminate the ambiguity of which samples were submitted to the laboratory and which samples were not attributable to Gannon Stauch's DNA. Additionally, there is an unknown contributor in some of the DNA profiles that were developed. As mentioned elsewhere in this affidavit, I do not have a biology background, but I am aware that a DNA profile is very accurate. Investigators submitted swabs from Gannon's toothbrush bristles, toothbrush head, and from a tooth retainer that Mr. Stauch said belonged to Gannon. DNA buccal swabs were also taken from Gannon's biological father, mother, and from Letecia Stauch. From these samples, DNA profiles for these individuals were developed and used as a comparison for other testing. In summary, Gannon's DNA was found from blood samples taken in the garage on the outside of the 8.5 Nike shoes, so the shoes she was wearing that day, Gannon's bedroom, and Letecia's DNA was recovered from the interior of the Nike shoes. I submit to the court that lab results tend to corroborate the theory that Gannon was indeed murdered in his bedroom, brought into the garage, and his remains loaded into the Volkswagen Tiguan, and subsequently to be disposed of at an unknown location. Yeah, Jane Doe, me too. And nothing else. I'm glad she was sloppy and it led to finding Gannon. I will say, though, that them finding him was literally just by chance. That was God. God put those workers down there under that bridge when they did to find his remains, because I'm telling you, that area flooded like not even a week later. It was right around hurricane season and everything else, and they were getting bad storms like not very long after they found his remains, and it all flooded out, and he would have been gone. I bet you he would have been washed away to sea. And it's just by chance that she was dumb enough not to make sure that he fell into the water. Yeah, it was Jane Doe, a complete miracle.
We've lost sound. Did you mute or
I
did
did
you
mute.
unplug
Sorry.
your?
I'm back.
Okay.
No, I'm back. Sorry. She fell and she scraped her knee and she's like, I need to go to the hospital. I was like, I'm pretty sure we don't need to go to the hospital. I think we'll be okay. So hmm, where are we at? Okay. So then they're going to talk about where all the places that they took DNA from was. What they mean?
I want pink one bath.
You want a pink one?
Yeah.
Okay, give me 1 second so I can go get her a pink one.
You have to love pink. At least they're not toddler wrestling today.
So glad your kids are all grown. That's funny, Rexy. You know what though? It's nice. It's nice. Okay, so I'm not going to read all of like the specific numbers and stuff like that, but basically they took DNA from a carpet that was in the utility room, from the garage, directly under where the rear hatch of the T-Gon would have been, and from the rear hatch of the T-Gon when it, yeah, from the garage, from the garage twice it says basically. Another sample from the garage, a sample from the carpet at the base of the garage stairs, blood-stained carpet fibers in Gannon's bedroom, the corner of Gannon's bedroom, on the carpet pad, the electrical outlet by his bed, another electrical socket by his bed, and from the backside of the carpet in his bedroom near his bed. They also, from the foam, from the top of the phone, from the carpet in his bedroom, from the trunk of the Volkswagen, from the teal couch pillow in the basement of the Stauch residence, which was found to have blood on it, and from the outsole of the right Nike shoe. So that's all the places that they sampled for blood, and found matches. It looks like they were all found, but not all of them were able to establish a DNA profile. And that happens sometimes whenever they're cleaning stuff up. Yours are all 4 years apart and they still get too rowdy on the daily. That's the only thing about doing this, is because it is like, it's right in between their nap time and their awake time, like whenever he keeps going to break. And so, and my middle, she doesn't really nap as often anymore. And so now they kind of sometimes they'll, you know, they get rowdy while they're playing, but they always have someone watching them. They are being taken care of. It's not like I'm just sitting here ignoring them and things like that. So they are good in that aspect, but obviously diaper changes and things that they can't take care of, I do. So, okay. Investigators applied for and were granted search warrants by this court to obtain historical cell detail records to include cell site locations of cellular devices known to be utilized by Letecia and Harley. Your client has reviewed information from this analysis and, in summary, learned the following information. Historical cell analysis helps to determine the location of cellular telephone based on cell tower antenna locations and orientation. Locations are determined by the activity of cellular telephone and represent an approximate area, not an exact location. Different cellular carriers report this information in different formats and fashions. I don't know, Jane Doe. I'm really, really trying to figure out how this is going to work. I don't know. And for those of you who are just listening and not reading the chat, she said, I'm really struggling with how a doctor could say she was insane at the time of the crime. The evidence we are aware of that shows planning before and after. Maybe I'm just worried a juror might believe it. I really don't understand it either. I don't get it. And that's the issue that I have with Colorado and how their system works, I think, because how exactly does it come down to a point where they're going to say, okay, the defense doesn't have to prove anything. Now that this doctor wrote off that she was insane, we just have to take their word for it. And so literally all of the burden is put on the prosecution to prove that she wasn't insane. And I think they have plenty of evidence to prove that, but you're right. Like, what if there is that one juror who will believe whatever it is that the defense is saying? She has proven many, many times over that she talked as herself to multiple people. And so how do you do that? How do you make it look like everything was fine and everything was, I don't know. How do you make it look like she was crazy and wasn't aware? Whenever she was referring to issues in her own life, when she was deliberately lying about things that she had done, when she is writing notes and shoving them down her pants in the police station, when she is, after the crime happened, texting and communicating with Albert and Harley. Yeah, you think they will say she was unwell for an extended period of time throughout the planning and cover-up? It's certainly possible. Certainly possible, but yeah, DID is hard to prove. We will find out soon enough, Amelia. I think so too. Insane equals a dissociation, not herself, and there will be other doctors saying she's not insane. Thank God she had seen so many in Colorado, right? There was really quite a few that have already seen and talked to her and all the things while she was trying to get her competency removed. And so that is, that's a good part, I guess, right? Okay. Okay, so the historical cell site analysis identified unusual activity for Letecia, including potentially disconnecting her cell phone from cellular networks for several hours. I submit that by disconnecting the phone, Letecia intended to prevent law enforcement from being able to determine her location. Specifically, this occurred on January 28th, 2020, during the evening that she disposed of Gannon's remains. Investigators applied for and were granted a search warrant for Letecia's cellular telephone. A physical download was conducted, and investigators were able to recover data inclusive of text message, call records, and the specific times her cell phone was unlocked, battery levels, and other information. In summary, investigators learned that Letecia lied to her employer, her husband, her friends, her daughter, and the children's babysitter, which I will not include each and every text message or lie, but you better believe they're probably going to show us that during this court hearing. Additionally, there are messages that would otherwise tend to corroborate her statements about Gannon's whereabouts on the afternoon of January 27th, if he did in fact go play with his friends. As discussed in other portions of the affidavit, Letecia's story was false and misleading, and these messages were likely sent by her as a larger plan to support her initial lies about his disappearance. For example, on January 28th of 2020, at approximately 5:14 a.m., Letecia had a conversation with Stephanie, the children's babysitter, saved in the phone as Stephanie's sitter. There is no indication that Gannon ever went to a doctor. Letecia never brought that up with investigators. Some, but not all of their conversation is below. So this is the messages that we showed the other day that says about like, well, this happened to after 3:30. We talked with him and she told him to be home by 6, and someone posted that he wasn't at school earlier. We looked at these the other day. He had to go to the doctor for his stomach, but he wasn't here in the afternoon. And she asked, well, where did he say he was at? And she says, I don't keep up with friends. We looked at that screenshot. I don't know when it was. Let me see. I'll pull it up real quick. It's actually better to see it on here. That's this one here. The back and forth. So we looked at that, and then they also talked about the reward in this one that I have up, but that was later. Oh, I undoubtedly, Rexy, I think we're gonna get them all. I bet we're gonna get probably 20 a day. Hi, Ramblin' Rome. Okay. So Letecia made statements to investigators via text message that could be considered exculpatory in nature, related to the presence of blood in the basement of their residence, as seen in the text message below. I've talked with investigators that were inside of the Stauch residence on January 27th, 28th, and 29th. There is no odor of smoke, no evidence of smoke. In fact, one detective noted that the basement smelled like coconut and was very pleasant. So she obviously sprayed or lit candles or did essential oils or something along those lines to cover up all of the smells from the cleaning products before the investigators came in. Furthermore, I know that burns oftentimes do not produce wounds that will bleed profusely. So one of the things that she said was, when we came, uh-oh, yeah, okay. This one was between her and Nicole, and it says, when we came back inside from the smoke, there was blood on both of us. I didn't know what to do. I was scared. I would get fussed out about it, and I didn't know if he should go to the doctor. I kept trying to add the candle thing, but Albert kept saying it was a small and minor. I was scared. The basement was smoky, and when I threw the covers on everything, we both had blood. You don't understand how hard it is to be a stepmom. And yeah. So that was from the candle incident that Sunday, and these messages were sent at 2 something in the morning on the 29th. I will be broadcasting the trial every day, team Tina. Each day that they are in session, I will be streaming. The jury selection is voice only, but the trial will have cameras via WebEx. It will not be on TV, but it will be streamed on YouTube by multiple people. I am one of those people. So we'd love to have you here to join us while we watch. Yeah, Boo will. And so she admits to blood. She admits about them running outside. I still think that he was probably trying to run from her, ran out that gate or something along the lines with that gate. And she was doing a cover story about why they had ran outside in case that would come up or was seen on people's cameras. So the
I think
message
she was
below
also
appears.
doing a cover story to get rid of the bedding because the bedding was gone.
Well, the bedding was in the suitcase with him.
Yeah, exactly. She had to explain what happened to the bedding.
Oh, yeah. Gotcha. Oh, yeah. To Albert, you mean?
Yeah.
Yeah, exactly, Hillary. She wasn't insane at the time. She was mad and angry with her life, so she took it out on Gannon. She needs to be locked up and forgotten about. Pure evil. Exactly. Exactly. Okay. So, the below message appears to contain instructions from Letecia to Harley to purchase carpet powder, baking soda, trash bags on or about January 27th, 4:52 p.m. These messages are important because the investigators believe the purpose of these items was to clean up blood from the murder of Gannon. The text message was also referenced in paragraph 72 through 76. Investigators also recovered limited GPS and location data from Letecia's phone. There are crucial time periods, such as the evening of January 28th, 2020, that investigators were not able to recover location history because Letecia disconnected her phone from the cellular network or turned her phone off. Letecia stored several written notes within her iPhone. The majority of these notes contained what appeared to be usernames, passwords, or insurance information. There were several notes that appeared to reference her unhappiness in the relationship. Who writes notes to themselves about how they're unhappy in their relationship? Like, that's so weird to me. Do you like, was she using her notepad almost as a journal? What do you think in the bushes?
I think it was a slick, not saying it was saying it way of telling Albert, because she knew they were going to get into her devices and all that. She knew it. And that people would see that. And I think she wanted to let him know, him particularly. Even she didn't want the cops to necessarily pick up on it, but I think she was trying to send Albert a message.
Yeah, I think so too. I think so too. Especially whenever everything came out, like, just a big red, like, F you to him and Landon for that matter.
Yeah,
All of her internet activity and her Google searches and her notepad and all of that, just to let them know,
mm,
like, this happened because of you, type of
yeah,
thing, because of what you've done to me. I totally think so. You think she takes notes on everything to help spin her web? It's a survival technique she was using. Yeah, that's very possible. She was also bent out of shape thinking Albert was cheating, right? Yes, Amelia. I think so. Yeah, Walker, thank you so much for joining us. Okay, so where are we at? Okay, I was able to review some, but possibly not all. Probably, I'm going to say he's probably right here because he says possibly not all of the stored internet search history in the websites visited recovered from the forensic physical download and search of Letecia's iPhone. Between the dates of January 25th and 28th, Letecia viewed websites associated with searching for a job in states other than Colorado, such as Los Angeles, California, Orlando, Florida, Pensacola Beach, Florida, and Fort Lauderdale, Florida. She also viewed apartments and 2-bedroom rental properties in Florida. Additionally, she visited a moving cost calculator website. Like, she was planning to leave, and I don't understand why she did not just leave. She should have just gone. She could have just walked away and just told Albert to go pound sand and just left, and she didn't. Yes, Hollyberry, thousands prayed he would be found, and then he was. I truly believe that God helped Gannon get found. Okay. So Letecia's internet activity also captured the search for a rental car. She visited the website priceline.com on January 28th, 2020 at 8:17 a.m. I submit the timing is consistent with the accusation of the Kia Ria mentioned in this affidavit. Letecia appeared to use Google, a popular online search engine. I have included some of her inquiries to Google. People, if you're going to commit a crime, don't use Google. They will always find your Google search history. Always. It doesn't matter what device you end up trying to use. You know, the dentist went into his office and used a different computer he wouldn't normally use. Doesn't matter. They're going to find it. Don't use Google when you commit a crime. Along with the date and approximate time of the search, not all of her Google searches are included below. I submit that Letecia's search history is important because this history suggests she might have been struggling as a step parent. And additionally, she suggests she was not happily married to Mr. Stauch. See items 1, 10, 12, 13, and 14. While her search history alone does not provide motive to murder Gannon, it does shed light on her inquisitive thoughts of her position with the family, memorialized in the Google's search engine. Team Tina, I haven't seen them announce that yet. I'm keeping my eye out though, because I really hope that we are able to also be a part of Justice for the West Boys, because I'm so sad they still haven't found them. So I also direct the court's attention to the way that Letecia's search terms are entered. Letecia hits the period key instead of the space key multiple times while searching the internet, and approximately 44% of the searches listed below. I do that all the time on my phone. Like whenever I'm trying to type real fast, I bump the period instead of the space because they're like right together, and I'm just too lazy to fix it. And so I'm betting that that's the same thing. She was rapid typing things and was messing up. So this will be significant during the discussion of the search conducted on Gannon's phone, as we discussed above in paragraph 40 and will be further discussed below. There are other searches on Letecia's phone that use a period in addition to an additional search history over a longer time span that does exist that is not listed below. Blech. Sorry, I got like, whenever I start talking and talking and talking, I get like tongue tied. So I apologize, guys. I'm not going to read down through these. We did look at these the other day on one of our live streams, but basically it's about, let me just read a couple. Mom advice for a stepmom. My ex-husband's wife does nothing for her kids. I wonder if my husband's ex-wife is sending me Valentine's cards since I raised her family. And then my son burned the carpet. How do I fix? Smoke effects. Will a humidifier help? And different things like that. So she just Googles and Googles and Googles everything. All the way down to number 34, they're asking for our son's toothbrush, but said nothing is wrong. She was freaking out because they wanted his DNA. I'm gonna take a drink real. So in the bushes, what do you think about all of her searching and things like that? Do you think, I don't know. How do you think that'll all fit in with the DID? That's what I'm trying to tie everything that we're reading back to the fact that we know that they are trying to say that she has a separate personality that was part of all of this.
I don't know how those searches are going to tie in with the DID. I don't think that they do. Because I don't believe she has DID. And even if she did, I'm not seeing anything on those searches that would be from an alternate. I'm seeing everything in Letecia's world on those searches.
Right.
It all pertains to her marriage and all the things.
Absolutely. Absolutely. I think the
And
prosecution is going to have a slam dunk with the Google searches, because I'm sure, like they said, they didn't include everything. So there's probably going to be so much that they show that, I mean, can you imagine how many times she probably Googled? We're talking, she did 1, 2, 3, 4, 4 different searches within a 5 minute period or a 4 minute period. Do you know what I mean? Over and over again.
yeah,
Like she's just searching, 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 searching. And so I'm gonna guess that this probably went on throughout the entire course of these events.
I don't understand why you would do that other than the fact that she wanted to drop Albert some hints because she knew they were gonna pull her devices and things. Because didn't she Google stuff on Gannon's phone too? I thought I remembered her using Google on Gannon's phone too. But I think she used multiple devices. But
Oh yeah.
certainly my son burning the carpet, yeah, right. She's right there trying to set up something that fits with her narrative for them to see.
Do you think whenever she started Googling, school is out, is it okay for my kid to stay home alone? That was on the morning at almost 1 a.m. before all of this happened. Do you think she was planning to take off even and leave him home alone, but didn't want to get charges for like taking off?
No.
Or even, again, we go back to the theory that I have that she potentially tried to overdose him. Do you think she was going to leave him home alone after she tried to overdose him and then was going to come home shocked? Do you know what I mean?
N-
Herself before the whole Petco thing and all that. We're talking at 1 in the morning after the candle burning.
Maybe, or maybe she was just wanting somebody to see how hard it was working and taking care of stepkids without help because Al couldn't take off to
Mhm.
stay home with the kids. It had to be her.
Right. Right. Hmm.
And you could be absolutely right on your theory. I mean, there's
And she Googled 3 different times, 3 different things. First one at 12:55. No, sorry, 4 different things. Google law for kids staying at home. And then, sorry, Colorado law for kids staying at home. And then school is out. Is it okay for my son to stay home alone? Son is sick, but I have to go to work. Son's sick. Can he stay home? She was hoping that she could go to work and have an alibi for whatever his time of death was going to end up being. Do you get what
yeah.
I'm saying? But
Yeah.
then, she couldn't get a definitive answer. So then we went to plan B. We're going to drive him around and then be shocked whenever it happens that way. Yeah, I think so
Yeah.
too. True crime with Shannon. Multiple plans. Yeah, you think so too, chaotic. Hi, by the way. Anyways, that was just something I just thought about seeing those searches right there after midnight. Okay, so investigators were also to recover internet search history that was deleted from Letecia's phone. No time and date association was located with the data. I could only ascertain that the searches were conducted prior to EPSO seizing her phone on January 29th. Some, but not all, of the search history included below. Some of the other deleted search item or terms included travel planning, shopping, job searches, and other seemingly innocent activity. I have not purposely left out any particular search that would be exculpatory in nature, and I am not intending to portray that all of Letecia's deleted searches were nefarious in nature. It's okay, chaotic. I appreciate you being here. There's several of you guys that are listening during work, and I totally appreciate you guys, choosing to listen to this during your work hours. But don't be getting in trouble. Don't get in trouble, you guys. Okay, so some of the things that were deleted, but they didn't have a time history for, was find me a new husband. I feel like I'm just a nanny, not a stepmom. Husband uses me to babysit his kids. Are there any free money to move to from a or are there any free money to move away from a bad situation? My husband never posts about me, but does everything else. My husband only cleans up for the army, not me. I'm just a glorified babysitter. Find a new husband. Sent my husband sexual messages and he ignores them. Make my husband want me more. I feel like my husband uses me to babysit his kid and find a guy without kids. Yeah, there's so many of you guys. No, thank you guys. Thank you for making my workday go faster. Hi, Miss Rider Chick. Hi, Cassie. Yeah, earbuds are in. That's so funny. You guys are all at work, self-employed. That's good. At least your boss won't come in and yell at you chaotic. Okay. So this is about her consciousness of guilt. And this, I think, is going to play a big part in the prosecution because it's showing that she was aware of guilt. And this is just in the preliminary, arrest affidavit and things like that. Keep that in mind. This is 4 days before she was arrested, almost 3 weeks before Gannon was found. And I'm just going to keep repeating that. And I know it sounds redundant, but I think it's important to keep in mind that this is not everything that they know. This is just a tiny, tiny, tiny piece. So, during the first 24 to 48 hours surrounding the disappearance of a child, it is reasonable that an assumingly innocent parent or step-parent would be contributing to search efforts and fully participating in the effort to recover the child. In the 24 to 48 hours surrounding Gannon's disappearance, Letecia rented a vehicle, turned her cell phone off for approximately 4 hours on the evening of January 28th, washed her teeth on immediately prior to coming in for an interview, evaded law enforcement attempts to conduct a more in-depth interview, and did not participate in the search for Gannon. And that was something that my sister-in-law, was telling us that she was supposed to be out there searching and they had never seen her out. Not the first night, not the second night. They seen Landon, they seen Al. They never seen Letecia or any of the family members that came into town for Letecia out searching. She didn't show up for the prayer vigils. She was not there. And that was a huge, huge red flag to the community starting night one. And so that's, again, law enforcement picked up on that too. So on Tuesday, January 28th of 2020, between 8:48 a.m. and 8:54, Letecia instructed Harley to pull your car in the garage via text message, presumably to temporarily cover up any potential evidence left behind. To be clear, Harley has her own vehicle that was mentioned above in paragraph 13, specifically a Volkswagen Jetta. On January 28th at 2020, approximately 4:04 p.m. to 4:17 p.m., investigators asked Letecia for Gannon's toothbrush to recover his DNA. At 4:19, she did a search of her internet browser if they are asking for our son's toothbrush, but said nothing is wrong. At or about 4:31 to 4:33, Letecia has a text conversation with Mr. Stauch and said, "Something isn't right. I think they're hiding something." "Who? The police?" Mr. Stauch responded. Letecia says, "Yes, they asked for toothbrushes." What do you think they're hiding?" he asked. Also, on January 28th at 2020, at or about 10:45 p.m., she made a statement to investigators via text message. At the time of this statement, Gannon had been missing for approximately 27 hours. Letecia believed she was a subject in his disappearance without any prior prompting from law enforcement or notification of such. And so she literally texts the investigators. Ready for this? "What do you want from me? Because I have nothing. One of your very own leaked to me what you guys were doing. I did nothing and or am being set up. I'm not really even sure, other than that being told that by another blue with El Paso. I was told I couldn't go home to sleep, and on top of that, men were sent to a home with a minor female, and she was forced to stay there, not even leave for food. Every conversation that said, even at this moment, I can hear inside, 'What do you want from me?' And the detective responded, 'Come in to talk to me. I would just like information to find Gannon.'" Like, could you imagine unprompted getting a text message like that if you were the investigator? I'm sure right then Detective Bethel was like, "Yep, she did it." If they had
Mhm.
any doubt before that, yep. She did it. And that was on the 28th. Now, mind you, they went in the next day and found all of the blood evidence. So I guarantee you Detective Bethel was like, "Hey guys, get in there and search that house because something is going on." So after EPSO investigators seized Letecia's Volkswagen Tiguan on January 29th, she obtained a 2020 Nissan Altima. Investigators applied for and were granted a search warrant by this court to install a GPS tracker on the vehicle. Oh, wow. Investigators monitored this tracking device, which provided particularly useful information on January 31st. A map with some of this data is included below. This information will be discussed below and relates to the area north of Palmer Lake along Highway 105 South Perry Park Road in Douglas County, Colorado. In summary, investigators believe that Letecia utilized the rented Nissan to return to the area in which she disposed of Gannon's body. Indeed, investigators recovered a piece of particle board from this area with Gannon's blood on it. This information will be discussed below in more detail. And so it shows that she went up the highway from 416, 431, 441, 513, and 448. And basically she goes like in this little circle, and we're at these different locations. So it's really hard to see. I don't know if you guys can see that or not, but it's like a black and white map. Anyways, okay, the fact that Letecia came back to this area on January 31st is significant, and investigators have not uncovered any evidence that Letecia has family or friends that live in the area, or any legitimate reason for her presence in that area other than to dispose of incriminating evidence. I submit a reasonable theory for the fact that Letecia returned to this area based on the information presented in this affidavit as follows. Letecia disposed of Gannon's remains at nighttime and was likely nervous about the location she chose. She may not even have remembered exactly where she dumped Gannon's remains. Investigators believe that on January 31st, she went back to that area to view the area while the sunlight was available, to ensure no evidence was viewable from the road, to ensure his remains were adequately covered, and to prevent detection, to see if any law enforcement was in the area. Now, keep in mind, again, 4 days before she was arrested, 3 weeks before Gannon was found, they still thought he could possibly be in that area somewhere. I will be right back. Take it from here.
Yeah, they did possibly think he was in that area. They were still searching. I can't believe that she went back there. What do y'all think about that? I can't believe that she did that, and with the rental cars and everything, I can't believe that she thought that they weren't going to check the data from those cars. Yeah, they were going to check her car, but they were going to check the data from every rental she had too. I don't understand why she did that and what she was thinking. Sorry, y'all. I would love to chat back and forth. I can't see the
chat at the same time.
Yeah.
No, it's okay. That's the one problem with being a phone. I should send you my old computer once I'm finished with it. Hi, Ringo.
Right?
Midnight Angel, Ariel Sellers, they delayed again until September. And I'm not entirely sure. It was something to do with a request by the defense, I think it was. So again, we're back to, I think it was September 6th, I want to say. So yeah, this is also normal for a killer. So the insanity DID will be interesting to see how they make it fit. I agree. She isn't as smart as she thinks now. Maybe either she was going to try to blame her daughter, or by then she was going for the insanity narrative even then. Maybe. Maybe. Okay. So investigators were able to remove a computer chip from her Volkswagen Tiguan, which was examined by the FBI, and they were able to find out basically the location data from January 28th to the morning of January 29th. So they didn't scientifically evaluate it, but the raw data at the point of this affidavit anyways showed that she was taken off-road. It would have shown that, displayed the estimated location on the nearest road. Furthermore, the estimated location may have some degree of fluctuality of accuracy, estimated between 50 to 100 meters. So, hey Rexy, thank you so much for joining. Welcome to the Sleuth family. Oh, geez, I dropped my headphone. Thank you for joining. Yay. Okay. Where are we? Okay, so FBI agents, including Special Agent Donati, I don't know, took steps to verify and corroborate the data recovered from the Tiguan. In summary, they were able to take some of the raw data, including the location and timestamp compared to the other evidence. As with other forensic evidence discussed in this affidavit, investigators believe it to be reliable. For example, the Tiguan raw data was placed in the Tiguan leaving the Colorado Springs airport just after 7 p.m. on January 28th. This information matched the time stamp of January 28th Colorado Springs airport parking lot receipt, and the Tiguan's raw data indicated the Tiguan stopped near King Snoopers parking lot for approximately 10 minutes after leaving the airport, and between 8:08 and 8:18, they were able to review video surveillance footage from King Snoopers, which indeed showed a dark SUV matching the description of the Tiguan sitting in the parking lot during that same time period. Other footage, including video footage from a Wendy's restaurant in a separate location, helped to further corroborate the raw data. So basically, what this comes down to is they were able to follow the Tiguan from the airport up to where they found the board and other DNA evidence belonging to Gannon at the area of Highway 105 South Perry Park Road. And they believe that she was there between 9:15 and 9:30 p.m. So that's huge because like I said, they found evidence in that area and then it became what happened after that? You know, where did his remains go? Because they found the board, they found some of this preliminary evidence, but they never found Gannon. They never found Gannon until obviously 3 weeks after this. And I mean, they searched. They put so much effort into searching. It was amazing. Let me double check the court real quick, just because we are starting to get closer to 3. Just to make sure I'm keeping an eye on that as well, to make sure they didn't reopen it. Sometimes they talk before the jurors come back in too. No, not yet. Okay. I just wanted to double check that before I forgot. It is a lot to read. Yes. It's weird what they found though. Well, I really think it ties into the fact that, you know, she threw that board out of the back of her car there. And she even mentions, of course, they found a piece of wood along the road because, you know, it must have flew out of the back of the truck while I was driving or something along those lines. And then she comes up with the excuse that, you know, she, hold on. Sorry, I gotta check the. Hmm. Sorry about that. I had a message come in that I really needed to read. Hi, Connie. Thank you so much for joining, by the way, Connie. I noticed that you joined after the live stream just ended yesterday, and I really do appreciate you joining the Sleuth family. Yeah, she had excuses for why that board was going to be found there, and we had no clue about the board until she told us about it on social media. It wasn't like law enforcement came out advertising evidence that they found. Yeah, criminals have an excuse for everything. But it wasn't her, it was Taylor or Janelle. Come on, guys. Oh, okay. So I think what I'm going to do right here is I'm going to pause for a moment, and I want to pull up a video and play for you guys that is just a brief summary of Gannon's case because I have to go take care of something. It's a video that I made a while ago. I apologize if you guys have already seen it, but take this moment to consider it an and a like a short intermission and get yourself a drink, get some snacks, and get prepared for court to come back in. It's like a 15-minute, 20-minute video, maybe. So I'm going to play this briefly. Bushes, if you need to take a break too, that is okay because it's going to have a video playing, okay?
All right.
Springs, Colorado. Gannon Stauch was 11 years old when he was reported missing on January 27th of 2020. He lived in Colorado Springs, Colorado with his father, Albert Stauch, stepmother, Letecia Stauch, little sister, whom I will refer to as Elle, and his older stepsister, Harley. On the morning of the 27th, Gannon Stauch didn't attend school. According to his stepmother, he had stayed home because he had a stomachache. She then also alleged that he left his house around 3:15 p.m. to go to a friend's house, and that he had left in a blue fleece hoodie, blue jeans, tennis shoes, without his cell phone, no jacket, and no book bag. According to her initial statement, she became concerned when he didn't return home at 6 p.m. like he was asked to. She sent Harley to the park to look for him and also reached out to Albert to let him know that he didn't come home from his friend's house. When she was asked what his friend's name was, she told people she didn't know, that Albert took care of all of that and was always the one who kept track of the children, even when he wasn't there. Gannon was officially reported missing at 6:55 p.m. by his stepmother, Letecia Stauch. The El Paso County Police responded to her 911 call at 10:09 p.m. I know what you're thinking. Why so late? A call made at around 7, not responded until 3 hours later. The reasoning is because T was smart. She reported Gannon as a runaway. In many states, runaways aren't priority, so they get put to the bottom of the list of calls. This investigation, starting out as a runaway, gave T crucial hours and days even before investigators were truly digging into Gannon's case. At the time that Gannon was reported missing, his father, Albert Stauch, was out of town doing military training. Alarmed that his wife told him that his son was missing, he immediately returned home. He flew back into town on the morning of the 28th. Gannon's biological mother, Landon Hyatt, lived in South Carolina at the time of his disappearance. When Landon was notified that they believed Gannon, quote-unquote, ran away, she knew her son, and she knew that that was not the case. She immediately caught a plane and flew into town to help search for him. The morning of the 28th is when things started to fall apart for Letecia Stauch. That morning, she had to pick Albert up from the airport. Upon arriving to the airport, she rented a vehicle and left her Tiguan parked in the parking lot. When people asked her why she rented a vehicle, she claimed it was because of her lease. She didn't want to drive around searching for Gannon, putting the extra miles on her car. This didn't make sense to pretty much anyone on Facebook that she was telling this to because she only put 71 miles total on the vehicle while she had it. She then began to claim that she rented the vehicle because what if Gannon seen them coming and was scared and he might hide from them? This led to the obvious question of, well, why would he be scared and hide from you? Investigators think that the real reason that she rented a vehicle that day was because she put Gannon in the trunk of her car sometime in the early morning hours between the 27th and the 28th. Also on the 28th, Gannon was upgraded from runaway to endangered missing person. Investigators say that it was because the weather was below freezing that night with snow flurries. He was under the age of 13 and he requires medication. I'm sure that those reasons played into part as to why they upgraded him, but I also think that T's erratic behavior played a part in that as well. On the day of the 28th, she had been avoiding detectives' phone calls, text messages, and was acting erratically. She was disappearing for extended periods of time, and no one was quite sure why or where she was. On January 29th, T was supposed to meet with investigators around 10 a.m. She didn't arrive until almost noon. She also made a trip to the car wash before going to meet with them. It was during this interview that the investigators heard the first huge change in T's story. She actually brought notes to this interview and requested to read from them. In her new account of what happened on the 27th, T and Gannon arrived home around 2:30. They went into the basement where she was attacked by a man named Eduardo. According to T, this man held her at gunpoint, but for some reason he allowed her to go upstairs to send Elle outside to play whenever she arrived home from school at 3:15. She then returned to the basement where Eduardo essayed her over the course of an hour. At some point during this grueling attack, she claims she hit her head and she blacked out. She woke up to Gannon jumping on Eduardo's back and trying to fight him off of T. Helpless, she watched as Eduardo took a suitcase, a cardboard box, and Gannon. And she couldn't stop him because, unfortunately, at this point, she hit her head again and blacked out for a second time. Investigators, as you can imagine, didn't believe T's accounts of these events. Typically, if someone's holding you at gunpoint, they're not going to let you leave so that you can go talk to someone else in the house and then come back. Not only that, but T did not have any injuries whenever police responded on the 27th. She also didn't have any signs of injuries during this interview. The other thing is, T herself released the ADT security system records to Facebook. And guess what? Those records don't show any movement in the house before her and Gannon arrived home. We also seen camera footage from one of the neighbors, and we were able to see T and Gannon leaving that morning and then returning home. What we didn't see, however, was any Hispanic males entering their home or walking in the neighborhood. Towards the end of T's awkward interview with investigators, they seized her telephone. They also detained her while they applied for a search warrant to obtain her DNA. Letecia began stuffing tissues that she had used into her pockets and said that she was having chest pain and shortness of breath. Investigators immediately requested medical assistance, and paramedics from the Colorado Springs Fire Department arrived. T was then transported to the hospital via ambulance from EPSO for further medical assistance. Oddly enough, during the ride, T was completely unresponsive to questions by medical personnel, and she seemed to have a miraculous recovery once they arrived at the hospital. To be honest, this is the first of many medical issues that T has claimed to have during the course of this case, so it's no shocker really that this is how it started out. Investigators continued to detain her once she was at the hospital in order to get a DNA sample from her. They also tried to get a search warrant for a SANE exam, which is basically a rape kit. T, however, did not allow a rape kit to be completed. T herself told investigators that she cleaned up after the crime scene involving Eduardo. Investigators on the 29th found brushes in the dishwasher that contained traces of blood. They also used a reactant agent to find blood, and they found a lot of it. There was blood in the utility room, the hallway leading to the garage, in his bedroom, under the carpet. There was also blood on electrical sockets. They found blood on T's shoes, blood in the back of the T-gon, on the dashboard, on the glove box, and there was also blood on a teal couch pillow from the basement. We don't know the exact date that the DNA profiles came back, telling investigators that this blood was all Gannon's. Investigators didn't tell us till nearly the end of February that they even thought that he was deceased. January 31st is whenever T. Stauch did her backwards interview. She had to do a second take to pretend to cry and ask for Gannon to come home. Mostly, she spent her time demanding apologies. After that interview, with her belongings in tow and Gannon in the back of her rental van, she drove across the country. Through the weeks that we all continued hoping, praying, searching, looking for Gannon, she just continued her online presence, making excuses, pointing fingers, throwing up false accusations, false claims, even claiming that Landon's ex-husband had been involved in Gannon's disappearance. Seemed she was willing to throw just about everybody under the bus to take the heat off of herself. Unfortunately, every piece of information she put out just made herself look that much more guilty. It wasn't until she was arrested on March 2nd of 2020 that we learned the true horrors of the crimes that she committed against Gannon. I'm going to read you the timeline of events that happened the days leading up to Gannon's disappearance, according to the arrest affidavit and the preliminary hearings. On January 25th, Albert took his mother, who had been staying with them, to the airport, and he stayed the night in Denver so that he could fly out in the morning. On January 26th, T took Gannon and Lena to Garden of the Gods and Burger King. That's also the day that we seen T's sugar daddy account accessed. T's Google searches depicted her state of mind over the events leading up to the 27th. She was Googling things such as find real military singles, I'm overdoing all the work for my stepkids, their mom doesn't help. My husband's ex-wife does nothing for her kids. I wonder if my husband's ex-wife is sending me a Valentine's card since I raise her kids. One day, some people will wish they treated you differently. Why should my husband choose me over family? Between the sugar daddy account being accessed and these Google searches, it's safe to say that T was frustrated in her role as a stepmom. She may not have thought that Albert was giving her the love and attention that she needed. Perhaps he was focusing too much on the children instead of her. My personal thoughts are, she was never anticipating to be a full-time mommy to 2 little kids. She likely thought that they were only going to be there for a small period of time and then go back to stay with their mom. However, that just wasn't the case. Once they were there, Albert wanted them to stay there. According to T, later in the evening on the 26th, Gannon knocked over a candle in the basement. Text messages sent at 10:54 p.m. describe the candle incident and Gannon being very upset. T took photographs of the alleged candle incident, and then she also recorded a video, and in this video we hear Gannon crying. There's 2 different versions of this video out. One, people claim that they can hear him saying, I'm bleeding. In the other version, it stops just before that sentence would be recorded. I personally seen it as soon as it was posted to T's page. And I honestly believe that the original video did in fact have Gannon saying, I'm bleeding at the end. I think once people started commenting on it and pointing that out, she took it down, edited it, and put it back up. Slightly after midnight on the 27th, T started searching things like, my son burned the carpet, how do I fix it? Will the humidifier help if exposed to smoke? Colorado laws for kids staying home. School is out, is it okay for my kid to stay home alone? My son is sick, but I have to go to work. My son is sick, can he stay home? Suede repair kit for sofa. She also texted her employer that morning and told them that she couldn't come to work because her stepdad was killed in an accident. T didn't know that the school district had already planned to fire her. According to their records, she was let go that previous Friday for lying on her application. At some point through the evening, we also know that text messages took place between T and Albert about bath salts, and Gannon asking about bath salts. At 8:13 and 8:17 in the morning, Letecia took photographs of Gannon sleeping in his bed. He was quote-unquote sick that day, so he stayed home from school. Even though T claims that Gannon was sick, they spent the whole day running around. She went to Petco twice that day. Around noon, Al sent a text message to Gannon's phone saying, hey buddy, and Gannon replied about an hour and a half later asking if he could play Zelda. At 1:43 in the afternoon, Gannon's phone made a search asking, can my parents find my cell phone if it is off? Investigators have noted that that search they believe was conducted by T because it was similar to the format in which she worded her searches. My personal opinion tells me that this is likely where investigators are getting the premeditation from. That Google search was 40 minutes before she murdered Gannon. At 2:19 p.m., T pulls back into the driveway. 2:22 p.m., she enters the home. Investigators believe that T then takes Gannon into his room and murders him within the next 15 minutes. Gannon suffered from a fractured skull, a gunshot wound in the lower left jaw, stab wounds to the left chest and right back, 18 sharp force injuries in all. He had several defensive wounds showing that he likely fought back. All of this happened so quickly, and she had very little time to clean up before Elle came home. Once little Elle got home, T met her at the door, told her to go outside and ride her bike. She scurried to clean up as much as she possibly could. At 4:42, Harley arrived at the residence. She had been told to pick up little Elle. T then sent them to the shopping store with a shopping list, carpet cleaner, trash bags, and baking soda. She bought herself time, and that's what she needed. Time to clean up this crime scene. Time to get rid of as much evidence as she possibly could before she called the police to report him missing. Time before she had to lie and say that he was a runaway. At some point, we know that she stuffed Gannon inside of a suitcase with his blankets and his pillow. She then rolled him through the house and put him into the back of her Tiguan. The evening of the 28th, after she had picked Albert up in the rental car, she went back to the airport and retrieved her Tiguan. It was that evening the GPS data shows us that T drove the Tiguan to Highway 105 South Perry Park Road and left Gannon. If you remember, during the searches, they spent a lot of time in this area, sifting through snow. They eventually found a board with Gannon's blood on it and clothing that they believe may have belonged to him. For her backwards interview on the 31st, before she left town, T went back up to Highway 105, where she retrieved Gannon. Investigators were concerned after finding the board with blood on it that they may never actually find Gannon's body. With the wildlife in that area, they just assumed that perhaps he had been taken. In mid-February, T and Albert were communicating right around Valentine's Day. She was still trying to convince everyone online that she was innocent, and that Albert and her were sticking together, that they loved each other, and they would remain true to each other. She just knew that everyone owed her an apology, and that they would never find Gannon because Gannon was still alive somewhere, she claimed. She knew that they were searching the highway. She never thought that they would ever find him. And I think that she figured that eventually her and Albert would be able to get back together and life would go on as normal. The 13th of February, though, she starts telling Albert different versions of the story. I heard 4 different stories from her in a very short period of time. She claimed that she was raped by a man named Quincy Brown at her house and that Brown abducted Gannon. She even went as far as to send Albert a picture of this man. I think it was evident to her at that point that they knew that there was no Eduardo. Her second change to this story was that Quincy actually followed them from Petco. At some point, he was laying in the middle of the road in front of her. She stopped to not run him over. He then jumped up and got in the car and made her take him home, where he raped her. She also claimed that whenever the police arrived that evening on the 27th, that the abductor was still in the house, and she tried to tell deputies that somebody else was there, but they didn't pick up on her subtle hints. Deputies had checked the entirety of the house that evening, and no additional person was located. And then her fourth story, of course she had to explain why her GPS put her in the area of the highway where they were searching. She said that her and Gannon were near County Line Road and Highway 105 in North El Paso County. Whenever Gannon was riding his bicycle in the area, fell, hit his head, and then was abducted by Quincy Brown. In this story, Quincy was being driven by a man named Terrence. What's funny is these 4 stories, none of them add up to what she told people online. It all caught up to her, though. March 2nd, she was arrested, and thank God Gannon was found on March 17th. He was found in Pace, Florida, in a suitcase. 2 men that were doing work on a bridge actually located him. I think T thought that she threw him off and into the water. However, right where he was, there was no water, just rocks. As almost a taunt to his parents and internet people, around that same time she posted a video of Gannon in Hawaii, jumping off a bridge and waving goodbye. All of the details of his gruesome murder, all of the evidence that they have against T. Gannon still hasn't gotten justice. 2 years later, T continues to play games. She's sent letters to YouTubers, social media people, writing a storyline that sounded as if it was taken directly from the Twilight movies. She's claimed to have mental health issues. She's a vampire. She's gone by Taylor, Janelle, Dr. Stauch, Carmen, Angel, Leanne. She did 2 competency evals, turned around and fired her lawyers after she was found competent to stand trial, convinced the judge that she was competent enough to represent herself, just to turn around and then request a lawyer after seeing all of the evidence that Mike Allen has against her. We have only been able to read small amounts of the evidence, but they're telling us that it's 27,000 pages long. T has said she's had multiple different medical ailments during the course of this trial, and now's no different. She's trying to say that she has dissociative identity disorder, getting sent soon for yet another evaluation to be done on her. I think the judge is finally fed up, though. The writing is in the peanut butter. It's time to get this show on the road and justice for Gannon. They have 6 weeks set aside for the trial, beginning at the end of March, with actual trial dates beginning in April. Pray for this family and for these witnesses that this trial doesn't continue to get delayed. It's time for justice for Gannon. In the description of this video, I'm dropping the link for a petition. This petition is to urge the judge to allow media access into this trial. T wants nothing more than to hide and for people not to see the true monster that she is. So please sign this petition and share it. Thank you all for taking the time to watch this video. Please hit the like button on the way out and share. And if you're interested in seeing a second video about Gannon, please subscribe. Thank you guys so much for watching that. Obviously, the petition is no longer in effect, and we are going to have access through WebEx and things like that, as you guys have been seeing. I had to take care of some business and stuff, and I just needed a few minutes, and so I appreciate all of you sat by and watched that, even if you may have seen it before. That is a video that I made last year, actually, about Gannon's case, and it just summarizes so many of the events very, very well, in my opinion. Yeah, thank you so much, Moonrain. Yeah, the rating is in the peanut butter because, of course, we have our peanut butter attacks that happened against her. So thank you again, though, guys, for sitting by while I needed a minute there. Oh yeah, you didn't know how behind you were. Yeah, thank you so much. Thank you, guys. So, in the bushes, are you back?
I never left.
Oh, well, how about that? Yeah. Oh, man. No, thank you, Kimberly. Thank you, Emily. Yeah, the Terrence thing, though, I had to add some little pieces of comedy, right? Because whenever you're talking about such a horrible, horrible subject, you have to have those brief moments of levity, because otherwise we would just be depressed all the time, right? This trial, it's going to be depressing in a way because we're going to watch what's happening and things like that, but at the same time, we are still going to be getting justice for Gannon, and so that makes it happy.
We lost sound, Sleuth Mom.
Oh, thank you. Okay, so let me go back to the arrest affidavit. We are about 28 minutes out from court coming back in. Let me go ahead and try to join them again just to make sure he's not here yet. Sometimes they start a few minutes early and start talking amongst themselves, so I just want to make sure. Nope, has not started yet, so they have not started it back up. So we will keep going with the arrest affidavit, and hopefully by the end of jury selection, we will be completely through it. We're actually almost done. We're on page 25 out of 32, so who knows, we may actually finish in the next 28 minutes. And that would be great because I could read you guys the letters to the judge on Monday then during lunch break, because Lord knows the letters to the judge are just as interesting as the other crap she put out. That's where the peanut butter writing comes from, I believe. Do you remember how how much we laughed about the peanut butter stuff?
We're not done laughing about the peanut butter stuff.
I know, I know. We really aren't. That and egg Guardo, because she was insistent whenever she was spelling it on Facebook, she kept putting egg, and people were like, "N no." But then finally she said Edgar or Eduardo or whatever it was, but in the beginning it was all egg and people were like, this lady's dumb. Like she's literally making up a name or whatever." And it didn't fit, but, then there ended up she actually did put the, Quincy Brown and Terrence, and Quincy Brown was actually somebody from the Wanted, like, he had been aired on Colorado's Most Wanted just before she was arrested, and I believe that that's where she's seen his name. Many people believe that that's where she's seen his name, just searching and stuff, and so he, of course, was wanted for, um, sexual assault, I believe, if I'm remembering right. So it just, yeah. Yeah, the egg sides. You know what? Jukebox made this for me and I love it. We had this and then, of course, my little sleuth mom with a fork was making fun of it because back whenever I first started my channel, people were like, "But who is Sleuth Mom? Are you really Sleuth Mom? Like, and how do we know if the pictures that you're putting up are actually you?" And all these things. And we would joke around about Deborah. Let me pull up Deborah. If you weren't here the other day, you might not know about this part. Deborah Locklear, T's mom, was talking at one point in the Facebook groups, and they asked her to take a picture with a fork. Where is she? I always lose this picture. I save it somewhere every time, and I never find it. Anyway, so she took a picture with a fork, and we were, of course, making fun of that. And so whenever I first did my face reveal, it was a whole thing. So I took a picture with a fork. It's like, how do you know that that's actually Sleuth Mom? Well, like, here's Sleuth Mom with a fork. So hold on. It's pulling up very slowly, but it is pulling up. Sleuth Mom with a fork. So that was like part of my big face reveal to my members and stuff like that. You thought that was Humpty Dumpty. No, he actually was originally like a little egg holding a banjo or something. Like it was a little instrument, and Jukebox replaced the instrument with a fork for me. So, but Sleuth Mom with a fork. If you don't know the story behind all that, then it's just weird because it's like, why is that lady taking pictures with forks? Okay, where am I at? Oh, you know what? Have you guys ever seen this too? This is something I wanted to show a while ago, but I think I sent this to B Tim, honestly, so that he could have it because whenever you talk about people who do like disgusting things during these cases, there was a group that was ran by another YouTuber and several other people, and I'm not going to name them right now, but I'm sure once I show it, you guys will pretty much have an idea of who it was. And before we even knew Gannon was in a suitcase, before his remains were ever found, before anything, T had made those accusations and stuff like that. And there was this troll who made this picture of Gannon in a suitcase and put it out, and it was just absolutely appalling, and it infuriated so many people. And it was so I just hate whenever people do stuff like this, and, like, it was just let me find it. Just absolutely gross that they even approved it or let it happen or any of those things. And, hold on, it's loading. Maybe. Yeah, they put out this. And it was so frustrating because it was like, why did that person and his admins even approve this post to go up? It was just so infuriating. And if you have been following deets on the streets, you would probably figure out which creator I'm referring to, because other disgusting things that have happened in Facebook groups lately have come from that group. And so you would know kind of a little bit about that. But yeah, that was one of the most infuriating things. And that's actually how the trap door started, the Curious Trap Door and those ladies, because they branched off of that group to like go to a better group without having, horrible, horrible things like that happening. And it was so awful. I'm not young. I'm 33 this year, or 34? 33. I have to call my sister. My sister always knows how old I am. Yeah, it's awful. And like they put that out, and that was, like I said before. Yes, you think YouTube are finally beginning to clamp down on these people. I think so too. But I wish Facebook would. It's amazing the things that they allow up that don't violate their standards. And it just blows my mind because you can report and report and report and they don't touch it. But then you can say something like kick butt or something like that. And they're like, oh, you violated all of our standards, or, you know, it's just infuriating, honestly. Still no WebEx. Okay. All right, here we go. So we are on page 26 now, and it says investigators conducted several consensually monitored telephone calls with Mr. Stauch. Specifically, Mr. Stauch, at the direction of law enforcement, communicated with Letecia via telephone and email. These communications have been recorded and memorialized and consisted of hours of recorded conversation. I will not provide a transcript of these calls, but will summarize the importance of particular changes in Letecia's story, and will also include exculpatory information related to Letecia's statements. Letecia never admitted to killing Gannon. For the purpose of refreshing the court, here is a summary of some of Letecia's statements, whether to law enforcement, directly through the media, or to Mr. Stauch in recorded email and voice communications. On January 27th, Letecia stated that Gannon left to play at a friend's house and did not come home at 6 o'clock like he was supposed to. On January 29th, she said she was being held at gunpoint, raped, and Gannon was abducted by her rapist. Within Letecia's falsehoods, there are documents corroborated by physical evidence that would be near impossible to know without being intimately involved in the murder. Letecia has made statements to explain blood on the walls in Gannon's bedroom, blood on the rear bumper of the T-Gon, and blood in the garage of the Stauch residence. Details of the location of blood evidence has not been released to the media nor to Letecia and has been closely held through this investigation. Furthermore, Letecia has continued to provide alibis for her physical locations not previously disclosed to investigators. Her statements continue to evolve in a dramatic way and are remarkably different from the original report to EPSO. The majority of the conversations between Letecia and Albert began on February 13th, 2020, over several days. Letecia's story continued to change. During a phone call on February 13th of 2020, Letecia stated that Gannon was burned by a candle to the point that his skin bubbled, and that Gannon peeled the burns off and wiped blood on his bedroom wall. Mr. Stauch did not ask about the blood on the walls of his room during this call. The fact that she provided information about blood on the wall likely indicates her knowledge of the murder scene. Going back to DID diagnosis, how did she know about the blood on the walls if it wasn't her personality that killed him? That was all the way on February 13th. So we're talking weeks after. Yeah, DID explains all the different stories. Well, I bet that's what they will say. Right. Hi, Ree. You lost track of your age around that same time. You'll be 40 soon. I don't know how soon, though. Right? Right. So, on February 14th, Letecia had additional conversations with Mr. Stauch and provided 4 additional versions of Gannon's disappearance. So 4 different versions, all on February 14th. So story 1, when EPSO came to the house on January 27th, the abductor was still in her residence, at 10 o'clock at night. And she tried to signal to the deputies that there was someone in the residence. It should be noted that the detectives checked the entirety of the house and no additional person was located during that search. Story 2, she was raped by Quincy Brown at her residence, and Brown abducted Gannon. She knew Brown's identity because she saw the paper and his identification card fell out of his pocket that had his name on it. Letecia sent a photograph of Quincy Brown to Mr. Stauch via text message. It is noted that this photograph mirrored images online wherein Quincy Brown was listed as a most wanted suspect discussed below. So again, like I said, she's seen his name and stuff. I wonder how much her poor daughter, Harley will have to carry in this trial. I know. I hate this. I hate this for her. You join many Facebook groups and you find that they all tend to get pretty nasty. Yeah, it sucks. It sucks. What do you think in the bushes? Quincy Brown? Was it him?
No, it was not. He's innocent of this. I feel sorry for poor Al with all these stories.
Could you imagine being Gannon's dad at this point and hearing all this? And of course, I'm sure the detectives told him about the blood evidence. I'm sure they had some type of indication that there was foul play, and that's why he agreed to the recorded conversations to begin with.
I can't imagine. I can't imagine what he went through with this process and with her. And how do you wrap your mind around your wife doing something like this?
Right. Sorry, I'm just checking the WebEx again. We're getting closer and closer. Oh, they have it open. They're still muted, though. Okay. So, where was I at? Okay, story number 3. Quincy Brown followed her from the Petco, and at some point, he was laying in the middle of the road in front of her car. When Letecia stopped to avoid running the man over, he jumped into her car and made her take him home and then raped her. So, story number 4. Letecia and Gannon were near County Line Road, Highway 105 in northern El Paso County on January 27th. Gannon was riding a bicycle in that area and fell off, hit his head, and then was abducted by Quincy Brown. In this version of events, Quincy Brown was driven by a man named Terrence. The February 14th, story number 4, has several interesting considerations. During the period of February 12th through the 14th, it was public knowledge by virtue of media coverage that investigators were searching for Gannon in the area of Highway 105 South Perry Park Road in southern Douglas County near the El Paso County line. Eduardo is innocent too. Yeah. Justice for Eduardo. Poor guy. He got his whole egg life mixed up in all of this. Let's see. Letecia brought this location up on her own without prompting during a conversation and provided an alibi for why she was in the area. Letecia was adamant that investigators' efforts to search for Gannon in the area would be futile. This area turned out to be significant based on the T-Gon's location on January 28th, and Gannon's blood was found in this area, discussed below in more detail. Furthermore, as mentioned above, Letecia drove through the same area the night in her Nissan Altima rental vehicle on January 31st. I submit, based on raw data retrieved from the T-Gon, Letecia was in the area of Highway 105 Perry Park Road on the evening of January 28th, and Gannon's remains were dumped in the vicinity of that area. Letecia's story lays the foundation for a reason why investigators may locate Gannon's body with head trauma. On February 15th, Letecia provided additional conflicting stories to Mr. Stauch, including the story that Albert Stauch, she told Albert Stauch about Gannon falling off the bike was a lie, because it is what she believed he wanted to hear. Letecia stated the blood in the corner of Gannon's room was a combination of hers and Gannon's. In this explanation, she stated that the abductor anally penetrated both her and Gannon with an object, and she was tied up at some point in the abduction. The abductor was still present during the EPSO visit that night. So we know she cut herself. And a lot of people during the backwards interview said that they thought that they could see what looked like a bandage under her hand, like she had that weird sweater on that had the thumb hole. And this would be why, because she cut herself. She knew she had blood there. I can almost guarantee it. This is unfair, but I keep thinking of the cost of prosecuting this woman. Boy, she must feel special, right? I'm sure it is too. I'm sure it's definitely staggering. As many visits as they've had to do to the hospital and other places. Yes, Leo, still going. The jury should be back in just a few moments. So, Quincy Brown, age 37, was listed on El Paso County's most wanted list on February 10th. I was able to locate Brown's photo on KKTV News website, where they described Brown as a black male. It's noted that during one of Letecia's stories, she described her rapist as a Hispanic male. The photo on this website appeared to be the same photo Letecia sent Mr. Stauch. Brown has an outstanding warrant for failure to register as a sex offender and failure to appear. These warrants appear to have been open since 2018. Yeah, what a sick story. I know, right? Be right back, Bush.
Poor Al. I just can't stop thinking about him having to listen to all this, and the only thing he wanted to know is where his kid was.
Yeah, he just wanted to know where his kid was. It's sad. I know. How does someone think up such elaborate lies, Jane? Yeah, her mind is out there for sure. But no way I'm going to sit here and say that she has DID or that she's too crazy to know or any of that stuff. Okay, so I was able to find a criminal history for Quincy Brown, date of birth 10/21/81, which included but was not limited to a 2001 arrest for first-degree kidnapping. He pled to felony menacing. Investigators have uncovered no evidence to support Quincy Brown was involved in Gannon's disappearance. Yeah, people's imaginations are incredibly telling. When someone accuses you of something you would never do, remember, it is about them, not you. Their minds, not yours. I agree with that 1000%. 1000%. As mentioned above, investigators began to focus a search effort for Gannon's remains in the area of Highway 105, South Perry Park Road in Douglas County, Colorado on February 12th, 2020. There is not an exact address to reference due to the rural nature of the area. This particular location was deemed important based on raw data from the T-Gon on January 28th and from the rental on January 31st. On February 15th, searchers located a piece of particle board during that search. The particle board had a stain on it that appeared to be consistent with blood, and is pictured below. I have added a red circle to indicate the location of the blood stain. The particle board was collected by FBI Evidence Response Team and transported to the Metro Crime Lab on February 15th. The initial test revealed a positive presumptive result for the presence of human or high primate blood. Further testing was conducting, and a DNA profile was developed and compared to Gannon's on February 16th. That profile matched the DNA profile of Gannon Stauch and is documented in Metro Crime Laboratory reports. And of course, the photo's in black and white, so we can't see it. The reasonable explanation for the discovery of this particle board with Gannon's blood on it is that Letecia used this particle board during the disposal of Gannon's remains. The area in which the particle board was found is rural, and the ground was covered by approximately 6 to 12 inches of snow. Additionally, the area is rural in its nature and is likely populated by wildlife, including predators such as bears, coyotes, and mountain lions. Gannon's remains may have not been located, and while investigators will continue to search the area, it's possible those remains have since been scattered since January 28th. They honestly believed at this point that they may never find him because of the wildlife. They knew he had been there. They just had no idea what could have possibly happened. With the amount of blood in his room, it could have been a possibility that she would have dismembered him. And so that was something they had to consider as well. Obviously, that isn't what happened. She just put him in this suitcase and was taking him from place to place. And they did eventually find him, but they got to a point where they had to call off the search because they just could not find him up there. It's because he wasn't there. So the map below shows the area where the particle board was recovered compared to the GPS tracker from the Nissan and the Tiguan. And then it shows it, but it's also in black and white. So wiretap interceptions. Additionally, investigators were granted a pen register tap trace device order, a GPS pings, and cell site sector information. Investigators monitored Letecia's telephone and recorded hours of communication between Stauch and others. Each and every communication intercepted is not included within this affidavit. 80,000 pages they had, you guys. 80,000. I want to keep saying that. We have 32. Double check WebEx. Still no judge. They got about 3 minutes left, so let's try to power through this. As during other portions of the investigation, Letecia continued to provide different stories to different people about Gannon's disappearance. Letecia provided false information to her sister and other family members, during which Letecia provided multiple different stories of what happened to Gannon. Several of these stories were discussed above. On February 16th, at about 7:28, Letecia told a female believed to be Tila Cummings that she had been giving Al numerous false stories because she knows he will not believe anything she says. On February 17th, at about 1:53, she told a female she believed to be associated with Laura something that she was thinking about flying to Colorado to take a lie detector test to prove her innocence. During that call, she said, "They think I'm still in Colorado." On February 17th, at about 4:11, she told another unknown female she was going to take a lie detector test, but that test is not admissible in court, and no law enforcement would be present. On February 18th at 10:14, she called a number, which linked to fakepolygraph.com. During that call, Letecia stated she never got a confirmation number for a test she paid for. Letecia provided the spelling of her name, and before discontinuing the call, the unknown male said he would resend the results to her email. I viewed the website, and it says the following information, and it just talks about getting a fully verified polygraph test, basically. On February 18th of 2020, at about 11:16, Letecia called that number again. During this call, she inquired about an email she had received. The unknown male stated that her report was blocked by management based on the content of the questions, and stated that with any illegal activities, they reserve the right to not send the report. Letecia's response was the following: "What do you do now? Just delete it and go about life and keep the money?" "Yes, we do indeed," he says. "Okay, I gotcha. Thank you. Goodbye." Investigators contacted Luke, whatever, at the lie detector place, and they got information provided to investigators, including the questions and answers that Letecia had provided. They were the following. "Do you intend to answer these questions regarding your stepson truthfully?" She answered yes. "Is your birthday August 4th, 1983? She answered yes. "Did you participate in any way in causing harm to your stepson?" She answered no. "Did your stepson return home with you to your home?" She answered yes. Did you participate in any way in causing the death of your stepson? She answered no. I submit to the court that if Letecia had nothing to hide, she would not have to pay for a fake polygraph results. This wasn't her, though. I'm sure it was her other personality, Taylor or Leanne or Janelle. So, in conclusion, based on data by the FBI reported in the Journal of Forensic Sciences, I learned that over 71% of homicide cases that involve false reporting, they report the party is responsible for murder. To be clear, this statistic is not being provided as sole probable cause for the rest of the warrant, but as additional fact to be combined with others listed in this affidavit. Based on Letecia's internet history, it is reasonable to believe that she was unhappily married to Mr. Stauch. Oh, here they are. They're back. I didn't make it.
In this case, Ms. Stauch has a right to require that the attorney's office prove that she's guilty by the reason of doubt. She also has a right to assert not guilty by reason of insanity.
Wishes if you want to jump down. That's great. Thank you so much for coming up.
What? A culpable mental state is either generally intentionally, knowingly, recklessly, something of that nature. In the criminal law, there is a physical act that occurs. And then in most cases, there also has to be some sort of, we refer to it as mens rea, it's a mental state. So in this case, what the prosecution has to prove is the physical act. They also have to prove that Ms. Stauch was sane at the time that she did that. Can't remember. I can't remember exactly the last element, whether it is they have to prove that she's sane or they have to disprove that she was insane, but it's something along those lines. Okay. Would you be able to follow that instruction? Okay. And juror, take this off here so you can see where I'm at. Juror 23 on the end here. No, seated next to you. Oh, no, you're right. You're juror 23. That's right. She's juror 25. Okay, so juror 23, you had indicated that with respect to not guilty by reason of insanity, you said this is still not a reason to do this awful thing she did to an innocent child. Do you still feel that way? Okay. Are you able to give Ms. Stauch the presumption of innocence? Okay. And I need to ask this question, but I think I understand where it's going. With respect to a plea of not guilty by reason of insanity, would you be able to hold the people to their burden of proof that they require that they prove that she was not insane at the time? Sure. It was a long way around the barn to get in there, wasn't it? Um, would you be able to hold the people to their burden of proof to prove beyond a reasonable doubt or disprove that Ms. Stauch was insane at the time? Okay. O- Okay. Um, in order to prevail in this case, the prosecution will have to disprove beyond a reasonable doubt that Letecia Stauch was insane at the time that this crime was committed. They have, right, they have to prove that she was not insane. Are we on the same page there? Okay. Do you think that you can hold them to that burden? Okay. But as we sit here today, you're not sure that you can continue to presume that she's innocent. Okay. Juror 39, you had said that you worked in education and domestic violence. I think we had talked about this a little bit earlier. And how about you? Can you give Ms. Stauch the presumption of innocence to which she's entitled? No, help me understand. It's okay. Just do your best. Okay. Okay. Yes, now that does. Okay. So it sounds as though as a general principle, you can, just not in this case. Is that fair? So for you, it's the past work experience that you have in a area involving children. Were these children that were victims of domestic abuse or what? Ah, okay, okay, all right. I get it now. Okay, all right. Juror 44, second row in the sort of black and white plaid. And don't get mad at me if I got the plaid wrong or something like that. Fashion is not my deal, okay? Um, okay, you had said that um, as the way you see it now, and it sounds like it must be based on something that you read about this case, that you believe that she is guilty. Okay. Now, you've heard me talk about the law and those sorts of things. How do you feel about it now? Okay. Do you think you could be a fair and impartial juror in this case? All right. And then juror 57, next row back, I think the red hair. Last name card? Yeah, okay. Juror 57, part of the problem I know is with the typographical that we had in the questionnaire, because question 24 says, if you answered yes to question 24, which is the one that you're answering, so I get it, but you circled both yes and no and then wrote possibly underneath of it. So help me understand, because the question had to deal with a plea of not guilty by reason of insanity. And you said, do you have any opinions regarding the use of the plea of not guilty by reason of insanity? You said no. And then you said, will you, if you answered yes, will you be able to set that opinion aside and render a fair and impartial verdict based only on the evidence presented at trial and the instructions given to you by the judge? You circled yes, no, possibly. What was going through your mind? And do you think that you could do that? Okay. I'm sorry? Okay. I appreciate it. It's all good. All right. With that, what we're going to do at this point in time is the attorneys are going to have an opportunity to ask you some questions. We're going to start with the prosecution. Prosecution.
Afternoon, everyone. Friday afternoon, end of the week. Our fourth group. I'm working on the topic, okay? So my job is to try to get you guys talking because that's what really matters. And so probably this is only 45 minutes. So I may not be able to talk to all of you, so I'm gonna pause. But if I ask a question that you'd like to answer, just raise your hand. Get to you. Go. Go. I'm gonna pick up right where the judge left off. Several of you indicated you had problems with the not guilty by reason of insanity plea. Now, you learned a little bit more about what that means when you came up to the courtroom, right? Because the court did a great job of explaining that to you. Is there anyone here that does not think they can give both the prosecution and the defense a fair trial because there's a plea of a not guilty by reason of insanity? If there is, raise your hand. Okay. I'll come back and ask Ed after we talk to Jeremy. How you doing? Tell me what's going on.
I have 4 children.
I appreciate you. Didn't say anything, we've never known. So thank you for saying that. And I'm glad you're the first person we talked to because that is exactly what we need. Is your answer. No such thing as a right or wrong answer. It's got to be your answer, okay? And I'm sorry you did that, but you did great. Okay? I don't think you have to worry about it. Anyone else that raise their hand? Yes, juror 53.
I think it's just a way of getting out. Way of getting out and every year, but or a mental hospital. Just trial.
Should be saying that you're awkward. I have an open mind. What else that raised your hand as to the not guilty by reason of sin? Yes. You're thinking this is juror 43.
Thank you.
Great question. Let me see if I can answer everyone else. It's two processes. There's something in the law called an affirmative defense. Most people recognize self-defense as a defense. I'm sure everyone's heard that. That's also an affirmative. So this was a self-defense case. You would probably hear an opening statement where the prosecutor doesn't say, that guy got up in the bar and punched somebody in the face. That's what say, yeah, they punched someone in the face, but they did it in self-defense. In other words, there's a justification for why they did it. They're saying they have an affirmative defense. And so in a self-defense case and in an insanity case, people have to prove first that a crime was committed. Secondly, we also have to prove against any affirmative defense. In other words, the burden would be on us to prove that it was not self. Does that help everyone? Because you're not the first group that's brought that question up. Does that help everyone a little bit more on how the defense of insanity is tied in with our burden of proof for the charges as well? Anyone else have any issues with insanity? Okay, you are juror number 18. Go ahead. No, we don't ask people to leave their experiences at the door when you come in, and so you don't need to say anything else, okay? I appreciate you telling us that, right? Anyone else? Yes, we have juror number 45, is that right? 45.
I don't have any problem with it. Like
That's the difficult part of this process of the trial, the jury selection. You can't come in and say, hey, here's the facts. Here's some more facts. Here's the law. What do you think? Can you give it your? We've got to ask questions about getting into the evidence. But you really don't know much about the case because believe it or not, the media gets it. Media gets it wrong a lot of times. So what we can ask you as jurors, the only thing we can ask you is to have an open mind. Humor innocent. Until you hear or unless you hear evidence tells you nothing. And it's a tough concept because we all want to answer from our gut, right? First thing that comes to our minds. You know, she's here for a reason. She must be guilty. People want to get off because it's an insanity plea because I heard about this. You have to have an open mind and just sit and be patient, listen to all the facts. Don't render a verdict until you get all the facts. Then that's when you go back to 11 other jurors and talk about it. Facts, get the law. I know it's tough to say what I'm going to do in the future when you don't know much about the case, but that's all we can ask you to do. You can be impartial to both sides. Wait till you see the evidence and the law and base your verdict on those things.
I think the thing that's fine.
Has to be on the jury. You're going to have to do it. Can you? I understand what I was just talking about there about being patient and waiting until you see the facts. Law. Anybody have a problem with that? Raise your hand. We can talk about it. Raise your hands. Number 45 brought up an interesting concept. One of the instructions of law that you will get is that sympathy cannot be a part of your verdict. Doesn't mean you can't be human and have sympathy. It means that you can't base your verdict on sympathy. That makes sense to everyone? Together here, what do you think our juror 40 or 28? I bring that up is because you know it's an 11-year-old thing. I don't know that. And so you know you're going to have to see autopsy pictures because that pictures center sympathy aside. $842. Anybody not do that? Push your mustache. It's the lesson for everyone. If I see facial movement, ask your question. How you doing, Jared? What do you think of that concept? You know, the other aspect of sympathy is sympathy for the defendant. Be here for however long this trial takes. You're going to be watching her and looking at her. Might feel sorry that she's in this situation. What's wrong with that? But what's your verdict on that? Are you okay with that concept? Everyone okay with that concept? Nodded head nodded. Let me ask this: is anyone not okay with that? Raise your hand. What are you doing, Juror 16? Heard from you. What do you think about this whole process? Very soft spoken.
Yeah, I couldn't hear. Can you?
Religiously, I cannot be part of determining someone's.
So you don't think you could be a fair and impartial juror because of your religious beliefs? You don't want to judge somebody, right? And there's nothing wrong with that. And I appreciate you bringing that up. Is there anything else I can answer for you? Do you have any other concerns? We'll call here juror number 12. Retired engineer, right? Is 1 + 1 always equal 2? Now, I want everyone to remember that. Because I'm going to talk about reasonable doubt. But everyone in here thought that 1 + 1 = 2.
Yes.
Yes. 2 days ago, I had no one that said that. Now I've got everyone saying. Why does 1 + 1 not equal 2?
Chemical propositions that can be combined where the sum of the two doesn't equal 2.
Does everybody know that?
I'm just saying, all right.
No, I'm gonna pick on you some more. Why do you think the burden of proof is beyond a reasonable doubt? And not just beyond any doubt?
It's the way the forefathers set it up. It's an interesting, I mean, it's legalese. Case has to be based on the merits of any facts that are presented. You have to prove it by factual information, testimony.
Okay.
Facts that are presented. Sure, there are instructions to guide us on how we're supposed to interpret that.
Sure.
But that's part of the discussion among the jurors. Based upon the testimony that we.
And you'll get a definition of what beyond a reasonable doubt means. And you're right, lawyers wrote it. But it has words in there like common sense and important decisions to you, and that you don't hesitate in matters important to you. Actually, the court read it earlier. But my question is a lot of people may come to jury service and they think, I want to be satisfied beyond any doubt. And that's pretty tough to do, right? Because unless you witness it, you may not be satisfied beyond any doubt. Is that a fair statement?
Yes.
And if you're a witness, you can't be a juror, you'd be on the witness stand, right? Not too bad, was it?
Help you with your problems.
Lawyers can. We'll do the best we can. What do you think about that, Juror 11? And you know what's cool about the whole reasonable doubt thing is you and the 11 other jurors really determine what the reasonable doubt is. You get to listen to the evidence, you get to look at the law, and then you as a group talk about it. Did the prosecution meet their burden beyond a reasonable doubt to each element? Did the prosecution meet the burden beyond a reasonable doubt that she was legally sane at the time of the crime? Can you do that? What else is going through your mind? Anything?
Yeah,
You want to talk basketball? We can talk basketball. I'm kidding. We can't
too much. I guess I would like a better understanding of
This is a great transition point to my next topic, okay? Have you ever heard the term actions speak louder than words? What does that mean to you? So I'm not going to do this because I did it the other day and it didn't work very well. But if I walk over and take a drink of water, do I need to tell you that I'm thirsty? Form that opinion by watching me and do what I do, right? Do you think you could do the same thing in a criminal case? You hear facts of a defendant's actions and you determine what's going in that defendant's mind based on his or her actions. It's the same thing with insanity. A mental state. What is their mental state at the time of the crime? You're going to get a definition of what insanity is in the state of Colorado. It's not listed out in neat elements like the crimes are, but you can break it down to determine whether or not the defendant was legally insane at the time of the crime. Does that help you at all?
Yes.
Again, it's one of those things, you don't have the law yet, but once you have the law, it might make no sense to you. Okay. Juror number 2, how are you doing back there? You've been training your whole life to be a juror, you know that?
I have.
You sure have.
That's news to me.
What do you think I mean by that?
I make up my mind one way or the other.
Probably made a lot of important decisions in your life, haven't you?
I hope so.
And you probably had some doubt when you're making those decisions, right?
Always.
But you still feel beyond a reasonable doubt, for instance, that it's the right thing to do and you make that decision.
Correct.
Does it make sense now you've been training your whole life to be a juror?
I guess so.
Well, good. Any questions?
Nope.
Juror number 7, how are you? You brought up something this morning and I forgot what it was. Was there something that you wanted to talk about? My life experiences are probably a little too much as well, so I appreciate it. What do you think about the whole concept we've been talking?
I guess I feel like I
The law says that you can't speculate as to what the evidence is or isn't. All that? So at the end of the day, we present all our evidence to you and you go back in the jury room and you say, I bet you this was going on. Like you do when you watch movies, try to predict what's going to happen. You don't hear about it, you can't consider it. All that?
I'm not objecting. I think that's an incorrect statement of law. One, there's circumstantial evidence they can on facts from another fact, and 2, reasonable doubt can be based upon the evidence or the lack of evidence.
I'm going to allow it, you can ask into, or you can inquire into it at the time of whether the jury should be advised, though, that you're going to hear a lot, the attorneys, about what the law is. And after this case is done, you're going to get an instruction that says the attorneys have advised you about the law in this case. You're to be guided by what I say about it. And so keep in mind that there are instructions that are coming.
All I'm trying to say is you have to base your verdict on the evidence. That's all. Number 8, how you doing? Good. 2 kids, can they? You ever have to interrogate them as to what they did or didn't do on any occasion? At the time. I remember those days. Situation where the 10-year-old may say something different than the 8-year-old as far as how do you resolve that? You find on occasion that they eventually come around after they sense that you're not buying what they're selling and tell you what happened? I think people do that in the criminal justice system.
From my experience,
You ever find yourself in a position of weighing someone's credibility? I'm not gonna ask a follow-up question, but how do you do that? For instance, in a trial, you're a prior juror, you've got, and I'm gonna be specific, you got an expert witness saying one thing, another expert witness saying the opposite. you resolve that?
Oh,
I don't know if everyone can hear your number eight, but you correct me if I'm wrong, but you're basically saying you can look at the other evidence in the case, see what makes sense, and what doesn't make sense. Is that fair? Does everyone agree with that? Can everyone do that? I know the answer to this already, but has anyone here had any experience with people who are mentally? A lot of hands. I'm gonna see if I can talk to someone who hasn't talked yet. At least me. All the eyes shift that way. What do you think? What, if you don't want to talk about it, I can go to another juror, okay? But what's been your experience with people who have mental illnesses? What? Sounds like he may have more serious mental illness. You agree with me that there's a broad spectrum of people that are more severe than others? May not be able to function in society. Decipher that in a criminal case. Anybody disagree with what juror 57 said? Juror 58, what do you think?
Hold it.
Sorry, you have to speak up.
I'm sorry.
You think there are people who are mentally ill that are legally sane? Would it surprise you that the term insanity is not a medical diagnosis? Something like schizophrenia, perhaps, that's a medical diagnosis, right? So how do you determine whether or not someone who's mentally ill is legally sane? Yeah, that's right. Does anybody disagree with that? 57 and 58. Oh, really?
A little hard of hearing, so.
Okay, sir. Did you ever hear much of anything today? We're talking about legal insanity. And people who suffer from mental illnesses. Some may be legally sane, some may be legally insane. But the mere fact that you have a mental illness doesn't make you legally okay with it. the mentally ill.
Yes.
They don't function in society. Take that off at all.
Who?
Off at all. Juror 73, you raised your hand first. He's hero mine, I love him. That's an issue, right? The water bottle's exactly right every time he goes to the side of tennis. Might be a little obsessive compulsive. But do you think he still functions in society, is able to follow the law and do what he's supposed to? What do you think? Yeah. Anyone else want to comment on that before? Very good. Okay. What do you want? Okay. So I guess. Talk a lot about the recipe to Denver omelet and the elements of a criminal case. Would it surprise anyone here that the motive, why the crime, is not anything that we have to prove in the court of law? There. I think it would be very difficult to prove why someone committed a crime. How about you, your, Ford? Do you think we'd have to prove motives? Why is that?
We were talking about evidence.
So you can follow the instructions of law, and if the elements don't include motive, you may hear against that motive, but it's not something we have to prove beyond a reasonable doubt. Motive is the reason why someone does. Take a drink of water because I'm thirsty. That's the motive. Also, my intent to pick up my water bottle and take a drink. So the intent may be an element because that's a culpable mental state, but the why or the motive is not. I mean, you see what I see in the news, the crime. For a rational why is the reason. Heard from Joe Fifty back there. What do you think about motive and not having a?
I think.
You said something there, and I don't know what you meant, but do you think actions can show a mental state? In other words,
It's been weird. I don't think. Church every Sunday. I can definitely see it just.
I think, right? How you doing, Mr. 47?
Yeah, following along.
Yeah. No, I mean, and everyone here is gonna have a different perception of what the evidence is, right?
Yeah.
Well, people listening to the same thing have different perspectives, right? So you're gonna go back into a jury. I've never been on a jury. I imagine you go back there and start talking about the evidence and you may have this. If it wasn't. Proof to keep talking and see if you come to a conclusion. Facts are, and the law is, and whether or not we met our burden of knowledge. Basically, what you're saying?
Yeah, you know,
Like I said, you gotta have an open mind. Go ahead, I'm sorry.
it's just an unknown.
Beauty about that is you have to wait till the conclusion of all the evidence. Before you render a verdict, so you can go back and say, all right, well, witness X said this, and witness Y said that. But the evidence, the physical evidence, or whatever the other evidence is, indicates this, and that is more in line with what witness X has said. Which can look at all the evidence together before you make a final determination on credibility purposes. You remember, how are you doing? You think about everything we've been talking. I know you're gonna get paid, right?
That's a little easy.
Yeah, I get you. We're good with that. Okay. Have we talked to your? I don't want to talk anymore, then, right?
I like to listen.
Okay. Is there anything I said that you disagree with?
No.
You understand that burden of proof is all on us. They don't have to do anything.
Thank you.
They're actually playing cards. If they do decide to call witnesses, then again, they don't have to. Challenge what their witnesses are saying. It might be a little heated. Okay with that if we do that. That would be our job as well as their job to challenge the evidence and cross-examine witnesses. Yeah, tested you in the past. They don't have to do anything. They're busy playing cards, so. I don't want to agree with that. How you doing over there, 21? Do you have any reservations about being on the jury? I didn't want to really bring that up to remind everyone else. It's a huge time. I think you understand the importance. Absolutely. By the way, I appreciate everyone. You do it, you put aside whatever things you may have be going on next 5 or 6 weeks. Questions? 23, how are you? What are you going to talk about? Helps, you know, helps that everyone here is wearing underwear. Kidding. This little speech thing, you know, when you get nervous. What's that? Any concerns about being on this trip?
Yeah.
Only that there's an 11-year-old victim in this. I'll use some observation. And you're the only one that can tell us this case isn't right. Yeah, tell us. Tell us. Let's see if you can do it. The last question I have for all of these group is, we spend a lot of time talking about presumption of innocence and beyond a reasonable doubt. And we don't really talk about when it comes time to render a verdict, whether or not everyone's comfortable with rendering a guilty verdict. If we do meet our burden beyond a reasonable doubt. You are satisfied beyond a reasonable doubt that the defendant was legally sane at the time of the crime. Everyone here return a verdict of guilty. That happens. Do not do it, raise your hand. Thanks. The flip side of that is if we do not meet our burden beyond a reasonable doubt, either to the elements of the crime or the insanity plea, and you all return a verdict of not guilty. Can't raise your hand. Raise it. Yep. Yeah, that's juror 53. Same reason we talked about earlier. Probably about out of time, aren't it?
You have about 4 minutes. You don't have to use it, but you have it.
I didn't really have to say the last part. All right. The last part of that is you're going to have a third option. That's not guilty by reason of insanity. In other words, if we prove the elements of the crime on a reasonable doubt as to the elements, we don't prove beyond a reasonable doubt that she was legally sane at the time. Everyone here render a verdict of not guilty by reason of insanity. Go ahead, 45, right?
Are you able to explain to us, like,
We'll get a jury instruction on that in your packet of instructions. Do it, but I'm afraid I won't do it verbatim. It's one of those things you're gonna have to wait and see what the instructions instructed on. Or it probably interject.
Yeah.
I guess I was asking because it was material.
The instruction that you will get will explain what sanity is. And there will be another instruction about what happens if a not guilty by reason of insanity verdict is reached. Does that answer your question? Yeah, yeah, there's an instruction that talks, it's a short paragraph instruction.
All right, I'm gonna get out on ahead. Okay, so I thank you for your time and I appreciate your service.
All right, thank you. Mr. Tellini?
Thank you. Hello, everybody. Well, thank you. I want to thank everybody for coming back after lunch. You didn't know that you ended up getting stuck with the United States News. I do. It's not an easy or a fun thing. Everybody, I'm sure, in this room has about 99 other places they would rather be than here right now. But our state and our county in particular has a pretty fantastic record of jury service. File stats every year about how many jurors actually show up for jury percentage. El Paso County is always in the top 1 or 2 of a county that really cares and understands, you know, how important this is. And I think that everybody has seen how seriously everybody is taking. I'll say this will probably be the only day that myself and Mr. Young agree on anything. And that is the important thing, and all that we care about right now is everybody telling the truth. I want you to tell me what I want to hear, what Mr. Young wants to hear, or even what the judge wants. Okay, sometimes I get worried when we have a judge like Judge Warner up there who, you know, if you're looking for like a TV judge that imposes on a judicial officer and has that authority, I mean, it's someone like Judge Warner. And I'm worried sometimes people want to give the answer that they think this is appropriate. That this isn't school. Jury duty, and your only duty right now, tell the truth. Tell the truth, how you're feeling, tell the truth where we are. Can everyone agree to that? All right. And then I think the judge said this isn't really jury selection. It's really more jury deselection. I don't get to pick anybody. It's not like we're, you know, out on the basketball court and we're picking teams. And they get their first pick and we go back and forth. People get excluded, and then the people who aren't excluded at what's called a challenger cause, meaning just by law, this isn't the case for you. They all get to come back to round 2 on April 3rd. And then each side gets to take 16 people off for whatever reason they want. And the next 16 people who are left, those are the people who are going to be on the jury. That's just kind of how this thing plays out. It's kind of like Survivor, except instead of getting a prize, you get special stuff. Okay, and also you guys aren't even on the island. This is just like the casting call. Who's going to get going onto the island. When we talk about challenges for cause, there's a couple different things. There's one called hardship. That means nobody likes being here, but for some people it's more unfair than others. I want to talk about those kind of first, and then we'll move on to some other issues. And hardships, I noticed some people I think are kind of shying on like public speaking. Not my issue. But I'm going to ask some questions, some stuff that people put down on their questionnaires, just so that we're understanding where to go. Because if you got on the jury, you can't then go, oh yeah, I forgot, I'm not available that week. If you make it, if you're on that jury, you're stuck. Okay, we'll send somebody else to go get you in and bring you in with us. So, jury number 2, on your questionnaire, you put down you weren't available April 17th, April 12th, May 3rd, and May 15th.
Doctor's appointments,
Okay. And are those doctor's appointments that you have to go to?
they're both for me and my husband. Can be.
Okay, well, I don't want to put anybody's health in danger. I mean, you've seen.
No, they're
Okay.
just regular doctor appointments. One CT scan. But all,
Okay. So those aren't, so if you're picked to be here, you can be on the jury and reschedule those appointments. Number 12, your daughter's receiving a PhD in Kansas, and you're planning on going there May 11th through the 16th. That's the plan. Okay, I understand that's a pretty big deal for getting a PhD. I mean, is that something that you, one, how important is that for you to be there?
30 seconds when she walks up on the stage.
And I
I can celebrate later
okay,
or before.
how important for her is it for you to be there?
We're there.
Okay, all right. And then also notice your son-in-law works for the DA?
Yes.
Who's your son-in-law?
Mark Brown.
Okay, what does he do there?
4th Judicial District, Division 21.
Okay, and so he works for Mr. Allen.
Yes.
Number 32. Said you may be unavailable May 4th through the 7th. Where are we going? Okay, is that something you had planned for a while?
Just me and a bunch of friends who are turning 40 this year.
What day is that? All right, you're planning to meet me on the Friday? Okay. Something you reschedule or?
No, but I can leave late.
Okay. All right. Journal 41. How often do you get migraines? Okay. I know.
Sure, that one's
And I'll tell you, and I'm not saying that. I think it's kind of, I have two concerns. One, I have the concern for you and, you know, physically having you here and you have migraine. Not sure what migraine is. Well, also, my paralegal suffers from migraines. I know when she gets it, she can't really focus on anything. It's almost like the pain takes over everything. So I'm worried, you know, with you that you're here, you have migraine, not for me. Okay. Yeah, I hate that. Okay. Your number 43. 64. You are unavailable April 6th and April 7th. Okay, so that's not you. Okay, were you planning north tomorrow?
Can you speak up a little bit so we can hear you a little better, please?
You're 75. Have you been able to hear us? Been able to hear you. Okay, well. You know, my voice is difficult in school. All the teachers said I don't have an indoor voice, but it worked for this job. On your question here, though, you said this would derail your life. I read the. Okay. No, I think you're not the only one. Upon further reflection, I can make that. Okay. Well, I'm a little concerned now because I'm going to be ripping your life too. There's no problem at all. It's good. Okay, are you sure? Yes. Okay, but don't want to derail anyone's life. No worries. Okay. And all right, so those are kind of the now kind of like the other things that are more specific to this case. Oh, I'm sorry.
Just a clarification on my daughter's PhD.
Yeah.
Since this only goes on Monday, Tuesday, Wednesdays, and Fridays, the graduation is on Saturday and Sunday.
Oh,
I
okay.
can fly rather than drive.
Okay. All right, anybody else though, and again, what we don't, we've all done a lot of trials, and sometimes people don't want to say anything and they're assuming I won't get on. I mean, if they get on the jury and as soon as they realize they're one of the people that all of a sudden like they're raising their hand, they've got something they gotta do. If there's something, vacation, out, that you want us to know about, it's kind of speak now or hold your peace. Yes, and that's your number.
66.
Okay. Okay. That's the one who's picking her up from the hospital.
Sure, 66.
Yeah, absolutely. And that's a great question. What I will tell you is you're doing, there's different ways to try to secure that she has a fair and impartial jury. And a jury that can give us meaningful consideration. Normally, like, this is like a DUI. Bringing like 25 people that we need, like 20 minutes, we have a jury before noon. 20. We know there's a lot of different reasons in this case. It's going to be difficult to get 75 people that can be fair. One, we're trusting people are going to be honest. Okay, that people are going to honest, ask them questions honest. Otherwise, this whole system doesn't work. And then we're going through, this is day 4 for us. Got another 4-day schedule next week. Go through 75 people a day to get them through. And so we're trying, because this week sometimes can be difficult to move trial to a different jurisdiction. We're seeing if this will work. If it doesn't work, then we may have to. But right now, we're seeing if we can get the right number of jurors onto that April 3rd who either have not heard about it or can take what they've heard and can kind of put it away. So that was a great question. So, number 44, what do you think about 166 then, for that question? Do you agree? I mean, kind of been rotating all this and Alan had a thing where he talked about blindfold. Probably see that's actually blindfolds on the scale. But the idea that everyone kind of equal, before the law. That we have, concepts that are the process that are in from the Constitution. And ideally, I think, that, again, the only thing we have all preferred money and immigration. Being a lot easier. I like what put on. But it is important. Everybody has a different fair. Yes. Following the state. Whether you're and you're wondering.
Kind of go on, but.
Here's where they following here going back. And I think that part of it, you read it, social reaction. That also makes you then some degree, in and out all of the sadness. It is. Yeah, I'm just telling you, I like to just be honest with you. And I know that's the answer that everyone, you know, that should answer, that's not dividing. But in the longer part, it's not only. At the beginning. Worry that someone's had. I don't. No. I, I don't worry that you would try, because I can see and I know that you. I worry sometimes about how people bring. You've heard of something called confirmation bias. Okay, so confirmation bias, the psychologist has done studies. And people when they're processing it. Highlight things that go to things that. Disregard things to go. Nothing. You know, so if you took a bunch of Democrats. And then go in to listen to, you know, what Republicans speak, they're just going to, you know, start anything on. They're going to be open-minded, but just how their brain processes information. As we grow older and older, someone's an evolutionary thing that you can go, I don't need to like fire another audit to process it. So things that are already pulled through is easier. So I worry with people that form an opinion already, even though they're going to try to wash it out of the way, that might not be possible. That's something, is that, you have that concern? And ours. I mean, you know, everyone has moral values and, or, you know, you could, emotions, you know, affect. Different example, I don't want to event. I love John Hill. And and him, how he managed Rocco to the very end. And people would tell me how horrible the GM is and everything like that, and I would fight everything. And emotionally, even when he takes a decision, they get that confirmation. But I wanted to that way. And so, I mean, it was an emotional thing enough for you that you actually you can.
We're searching for it.
Yeah.
Just trying.
Yes. That when trusted, all of a sudden 28. The wool, but his eye brains. Well, yeah, I mean.
Did odd things.
Report about kind of, and I'm getting a little bit stronger. What if I'm misreading? I'm interpreting what you're saying as incorrect, just letting you know. What I'm interpreting from you is understand all of this presumption and it says, and it's reasonable now and even it, and it's, you know, this is what our country is based on. And any, you know, if you were coming in and, you know, it's a DUI or a drug case or anything like that, these are concepts you could put into full effect. But because we're not going to know about this, because similar name, worry about, got some reservations on your ability.
Not because of foreknowledge. I'd say the foreknowledge I had was trying to do it, but soon facts that were, like at the end of it, say that somehow it's me. Justice in my hand. How comes down. Of course, between a water. I think there's like a bar of no way, there's no possible way. All other factors reason possible by.
Leave it all if it's like with the facts, worry about. I mean, can it reasonable out of the higher burden, like higher than likely than not, you have a strong belief. A lot of times. You wouldn't hesitate to act. So I've had to come back.
Yeah, I think it's what- like I think regardless of what it's like.
I don't know all that about the case.
Okay, well, we'll call it out.
Appreciate it, just kind of let it use it.
Oh, man. I'm sorry.
I know. It's a bummer. But no, I mean, it's kind of like what I had said earlier. I mean, I'm open-minded to.
Pretty, if you have kids were upset, you know. Because that's, you know.
Concern is being away from them.
Okay.
I'm involved with their high school soccer,
Oh, nice.
soccer. It's just something I enjoy doing. That's probably gonna be the hardest part.
I was like, I coach like this, you know, and it's great. It's great. What do you think about? And say the drive that it's a horrible crime and someone has to be held accountable. Overwhelming kind of, you know, holding them to the burden, maybe. Reservation that it could. Overwhelming kind of, you know, holding them to the burden, maybe. Reservation that it could. And I don't think anyone can guarantee it. And that I understand. I'm not asking, for a guarantee. I guess what I'm asking for is, anybody got a reservation, like about whether or not he's going. And I guess I'm gonna switch to the sports analogy here and just try to figure out where I can. If somebody wanted me to done basketball, then I can't do it. There's no way I can do it. I can practice, I can train for months, and I'm not gonna. Somebody asked me to hit a 3-point shot, maybe 2 out of 10, I can hit. Pro 50-50. And I've got a layup with, 9. On that kind of thing, if being able to do this job, where do you think you're at? Dunking, 3-point, free throw, play. Yeah, I mean, we got our cards, and I understand. All we're after right now is this. Juror number 73 back there. What are you thinking about this?
I haven't really heard it's either. I didn't follow it.
Okay.
Children.
Second one. 71.
He's 72.
Okay, 72 then. I'll take it. All right. So what is-
Oh, I'm sorry. He is 71. Sorry.
Just let the record
Looking at the wrong one.
Have you heard about the state's once before?
I heard it, about coworkers.
About this. I mean, it's. But, they say we don't have. Like a topic. I mean, you're doing everything. But the converter represents that, so kind of like the same thing I talked about before. Assumption is so high that even if you have a strong belief. I don't think you will. Possible. Better than that, not go for everything. I've got Bongo, you next. I don't even want to speak.
I don't know a lot about.
Okay. And then. And. Back to the sometimes. Sometimes people like, okay, like that's case or something. That 11-year-old kid. If no one wants to, hopefully I'll do my job well enough that it, like I just. But if it's not, that's what the law requires. Um. oh, Would his mental health. What I'm saying, which is like sometimes he seems like he's doing really well, and other times he's already. My brother, is the same. I'll be fine and lucid, and by the time I call him, I'm like, no, you're not John the Baptist. What I'm saying, which is like some. I think we're doing pretty well. And others, you know. And then what we're gonna be talking about. is that That's the time frame that we're going. Number 64, what do you think about all this? I'm gonna find a question here about the not killed by reason of insanity. Yeah. I don't believe it in a case like this. Why do you write that?
What little I heard. Somebody before up to me. I didn't know. What little I know about it.
Yeah.
I wasn't so sure. Now with. Open my mind to something.
And I guess I'm a little concerned with the scenes. Let me say this, I mean, yes, we presume innocent. All the evidence is done, they could argue, again, that's clearly, I mean. It is a lot of it, quite a lot. But that presumption maintains her throughout that. And if I'm misinterpreting, let me know, and remember, all we're asking for is the truth. What I'm kind of getting from you, and again, if I'm getting this wrong, is kind of came in here and thought, and then it is a bunch of BS. And you heard the judge talk about, you must kind of consider, insanity. That sounds like a long way though from presuming that she would be innocent. But am I misinterpreting?
No, I think that's pretty good.
Okay. But you consider it, but you would still highly speculative of insanity, as opposed to say self-defense. If we were saying self-defense, you look like, don't think it's wrong, but the type of guy who, you know, is down for self-defense. And that's something you wouldn't have a problem with, but insanity, you've got some inherent skepticism. Okay.
Yeah, I'm at the object, maybe approach.
Yeah.
So for those of you who aren't looking at the screen, there is a Amber Alert in Robinson, Texas. Candace Masterpool, 14 years of age. She was last seen wearing a black dress, white and gray leggings, dark blue Crocs, and she was abducted by what they are describing as a Hispanic female, ages 18 to 24, somewhere in that age range. Um, it's a four-door silver sedan. They believe it's a Mexico license plate, GAC51C is what the one says, and then the other one said no plate number. So yeah, so that's pretty urgent. I hope we have luck with this one like we have for the last three, because we have been doing great so far on them getting found pretty rapidly. So please, guys, say a quick prayer for Candace Masterpool, and I'll keep looking for updates as well.
This is insanity makes a presumption in a sense. Little tricky of a more of a tricky of a concept than other things. He's presumed innocence through according to everybody. There you go. Insanity is an affirmative defense, okay? And so for an affirmative defense, we don't just say not go by reason of insanity, you have to consider it. During the course of the trial, we are going to have to introduce some evidence of it. And help me introduce some evidence of it, she is presumed safe. Once we introduce evidence of it, then the burden on their table right here is to disprove it beyond a reasonable doubt. That makes sense. And what I worry kind of from what you said and rivaling a little bit about your facial expressions is if we were talking about self-defense, this is the concept that you're, because self-defense is the same way. We don't just go to self-defense and get self-defense instruction. We have to introduce some evidence that it was self-defense, and then they would have to disprove it. That makes sense. And what I'm getting from you is if this is self-defense, I'm down with this concept. But it's not guilt by reason of insanity, I'm pretty skeptical.
At this point, I would have to say yes.
Okay. Reporting. What do you, yes, I know, sir. What do you think about this whole, like the insanity as an affirmative defense? What's your comment? That's one of the points that that's how this, like, whole game is kind of.
You have about 5 minutes.
They, the box is all planned at 10, 9. No, that's it. This, I would say, is more, like football, where they're starting out in the drive the whole field. Doesn't matter if they drive 99 yards, let's see it across the goal line. Have to get into this. Okay. And it's every lawyer that this race. See if I can- 50. What do you think about that, Perry? I don't have. I understand the easiest way to make it out.
Yes, I understand. Yeah, I think that's completely valid. So
I've heard a lot of people think that's just a lawyer package. Yeah, I mean, is that a feeling that you have? And then let me rephrase it, that's the other question. Not goes by reason of sanity, you get. It's as valid as self-defense, and you get it the same way that you would something. Five. No, I'm sorry, I didn't mean to ask. But you're sure, 23, yeah, you're 23, that you're 24, sorry. Okay. 25, can you give not go by reason of sanity the same weight that you would give self-defense? You're not sure if you can give insanity the same. You give meaning on that rate than to the best. I don't think anybody's right.
Hang on.
Right, so.
I don't know
I'm
who's
thinking of-
talking and I can't hear the copy. So
Oh,
start
I'm
over.
sorry.
No, that's okay. Start over.
Thank you.
Okay. I wanted to follow up with a couple of things. Juror 66 in the back, you said that I thought it was your sister is getting out, is that right?
Yes.
And that is on April 3.
Yes.
Tell me what that's going to look like after she gets out of the hospital. Okay. So she is, I don't want to pry too much. What happened? Oh, yeah, Barre, yeah. Okay. Okay, so, but she is supposed to be, is she no longer on the ventilator? Okay. And so they're rehabbing her, trying to get her to a place where they can discharge her.
Yeah, she's in a rehab now.
Got it. Is she gonna have usage of her arms and hands? Got it. Okay, and juror number 20, I just want to talk to you a little bit about what Mr. Pelini was talking to you about the NGRI and the self-defense, because I think it's a pretty good analogy. Remember when he asked you about, and I'm sorry, we're on day 4, so I'm not exactly sure whether he asked you, whether this was somebody else, whether it was actually a different day. But let's go to the self-defense, okay? Somebody hits somebody else in the face, breaks their jaw. In that situation, that person may get charged with a second-degree assault causing serious bodily injury because of the fracture, okay? There is not a presumption that the person who did that was acting in self-defense, okay? It is something that if that person wants to assert it and say, I was acting in self-defense, then it's something that the jurors consider at that point in time, and the prosecution has to disprove it beyond a reasonable doubt. That's a really long way down through the pasture to get back in the barn. Did that make sense to you?
Yes.
Okay. In a not guilty by reason of insanity case, the law presumes that a defendant is sane and a defendant is competent. It presumes both of those things. Okay. So we start out with a crime is committed. The law presumes that a person is both competent and sane. Unless and until that is raised as a defense, at which point the prosecution has to prove beyond a reasonable doubt that the person was not insane and was competent. Does that make sense to you? Okay. And the question, I think that in this case, would you be able to hold the prosecution to the burden of disproving the defendant's claim that she was not guilty by reason of insanity? Only a lawyer could love that, because there's 2 negatives in there. But that's actually the way that it is the prosecution has to disprove the affirmative defense, and the affirmative defense is insane. So can you hold the prosecution to that burden?
I want to say yes, but without having everything in front of, everything presented in front of me, I don't know. That 100%.
Okay. And I think I see where, tell me if I'm wrong, because the lawyers will. So tell me if I'm wrong, okay? It sounds to me like you're saying, I need to wait and see the evidence. Is that fair? I need to see where the evidence shakes out?
I'd like to think that, yes.
Okay. But you understand that the prosecution, regardless of how this case goes forward, the prosecution has to disprove the affirmative defense of not guilty by reason of insanity. Would you be willing to follow that? It's a difficult concept, I know.
I want to say yes.
Okay.
Because I think I'm the kind of person, if I'm presented facts of decipher.
Okay. Okay. Here's what we're gonna do. We're gonna take a recess. Before we do that, let me ask, I've asked you a number of questions. The attorneys have asked you a number of questions. Does anybody have in the back of their mind something where they're thinking, they didn't ask me this specifically? Or they asked another juror this, but they didn't ask me. And I think it's something that if I were one of the attorneys in this case, I would want to know. Does anybody have any of those kinds of concerns or thoughts in the back of their mind, or even in the front of their mind? Juror 21, yes, sir. Mhm. Sure. Okay. No, that's exactly the kind of thing that we're thinking about. So the question that I have for you, sorry. So the question that I have for you is, I don't know what the experts here are going to say. They're going to come in and testify, presumably. Would you be able to judge their testimony and apply their testimony to the facts in this case, whatever those facts are, and make a determination based on the facts in this case? And I think what the attorneys would be concerned about would be if there was some experience that you had, you said it was your wife, right? If there was some experience that you had with your wife that you would say, well, that can't possibly be the case because my wife didn't have that, or she did have that, or she acted differently, or something like that. And so that can't possibly be the case. Would you do that? Okay. Okay. That's what I was trying to find out. Okay, what we're going to do is take about a 20-minute recess. If I can have everyone back in the hallway at 10 after 3, and the plan will be to bring you back in here, and at that point in time, we'll excuse other people, and we will have instructions for the ones that remain. So with that, all rise for the jury, please.
He's killing me. We could have went home like an hour and 10 minutes early today, but he did an extended lunch and now a long recess at the end. We could have got out of court early today, Judge. It's Friday. What are you doing? He didn't mute yet, so I'm just still waiting for him to mute officially. He will likely ask Letecia if she needs to go pee.
Thank you. You may all be seated. Record should reflect the jury has left the courtroom. Ms. Stauch, do you need a break? You're okay? All right. And this will help cut down on some. I intend to excuse 10. Okay. 10, 18, 53. There was somebody before that. 23. 45. 16. 41. 66. So if you have any others that you want to add to that, we'll take it up when we get there. Three. Right. Okay. Hold on, let me get through mine first. 45, 16, 41, 66. You said 39, right? Okay. And does the prosecution have anybody else that they wish to challenge for cause? Okay. Defense? Six. Okay. Tell me everybody first.
Got 8, 12,
Okay, 8, 8, 8. Okay, tell me give me your arguments with respect to 8.
number 8, on his questionnaire. Is there any specific type of case you're not thinking you can bear? Child abuse. Answer number 21, if you've heard, seen, read, or discussed anything about the case, you said that side and then prepare and part of the verdict. Answer no. I could try, but I'm not sure. Answer number 20. Teacher's house. Sanity. I think it is a ploy to
Prosecution?
Based on my question of juror number 8, gentlemen. His hands. Perhaps I should have been more specific. I don't believe he's like many others. So I don't.
Their silence on 2 questions is not. You have to overcome it.
I understand that case law. We're going to move on to, I'm not going to rule on number 8 just yet. We're going to move to question or juror number 12.
Yeah. His son-in-law works for Mr. Allen.
Follow-up questions were never asked how that's going to impact. Statutory costs. So.
Yeah, I'm going to circle back to that one too. Probably what I'm going to do is not excuse either 8 or 12 at this point in time and think about it over the weekend and see where we are. I tend to agree that I don't think it's a statutory cause, and I didn't hear anything else about that fact creating an issue or conflict or something else, I agree that generally we don't have those kinds of, or I don't run across those sets of facts very often. So I just need to think about that one, and it may be that I decide it next week.
The people who objected, the court wants to inquire both.
Oh, that's an idea. I may do that. Okay.
I guess would object to son-in-law's Brett Ross, who was trying. And but he went back. Very hesitant. Pauses before. Law and the court answered that case law, that line of cases is for you. That we have research on it. There is confirmation bias. They have an idea of facts coincide with that idea. Coming into this, that this is not an insanity case and he's not going to believe it. So he's trying to say what the court say one. That I think, but regardless of what he's saying on her ability to have an partner, someone that had the just coming in and saying, yeah, I can follow what the court says. I don't think that's a guarantee of an impartial juror when they're clear they've had their firm opinion.
Prosecution?
Yes, Your Honor. His answers as a whole. This afternoon, I asked him a question. He indicated that he could keep. I didn't ask him any questions because my job for me, I didn't need to go in and read them. I also asked him questions about, there's a presumption of insanity, which was not correct. So corrected himself. Came back and says, I have some skepticism. Say I couldn't do it. He says, I have some skepticism. Striking to the people is when the court addressed the issue again with him. Without the court asking, he said, I gotta see some evidence. I gotta see the facts. That's why I'm not 100% sure I can do it, because I haven't seen it, which is the right answer. He's got to wait and see, and I think he's another one that didn't appreciate what a plea of not guilty by the reason. They haven't filled out the questionnaires. We would object for a challenge.
Yeah, I'll deny the challenge for cause as to juror number 20. It seems to me, first of all, I think that I addressed the issue when I first came back because it was something that I saw in the questionnaire. And like we have been seeing with a number of jurors, they have come back and said, you know, I didn't have the law before I filled this out. If you're asking me based on whether or not what was reported in the news, if I think that she was guilty, well, then yeah. If you're telling me what the law is and those sorts of things, oh, well, I didn't realize that. Yeah, I can follow the law. I can disregard these sorts of things. The other thing is that I think that the sanity issue is a difficult issue, in part because I, I'm just doing this for the record, and I understand that the jurors are outside of the courtroom. Not guilty by reason of insanity is I did the act. It is an admission. I did the act. But there is a legal excuse for my actions. Technically, that's what an NGRI plea is. Now, I understand here that Ms. Stauch has the right, and she does have the right, just as every other defendant. She has the right to require the prosecution to prove beyond a reasonable doubt that she did the acts. But we're all taught in law school that the not guilty by reason of insanity is the acts were committed. I committed the acts. I just don't have the mens rea because of something else that is going on. And I think that the difficulty that I understood him to have had to deal with that concept more than the burden of proof on the respective parties. And Mr. Young is right. I mean, pretty much without prompting, he said, I'm just going to have to see how all of this shakes out, because I think he was having a difficult time with that concept. So I'm going to deny that challenge for cause. As to juror 32.
I'm going to withdraw for you. I had him down to D for the record.
Oh, right.
And
Okay.
I understand the court.
Go ahead.
I understand. My position record is I disagree with how the court framed. I think if you have the presumption of innocence, and once we are raised insanity, because we are saying that is how we get to innocent, then the presumption of innocence, once we raise evidence, we require the jury to follow the presumption of innocence. Well, that's been countered by the district attorney. I don't know how you can combine presumption of innocence with the affirmative defense. If that our theory of innocence, same as self-defense, and that's, I guess, I'm just saying regularly helpful.
I understand that.
Is great self-defense. Once that evidence come in, then the jury is required to presume self-defense is in play, and they would be not guilty by self-defense up until through the trial. My position is that the presumption of innocence, once we raise evidence of insanity, then up until the end of trial, and it's my position that the juror will of the law regarding the presumption. I understand.
Okay. Go ahead. Okay.
You're going to propose instructions in this. Essentially says there's a sanity. If the defense raises the issue of insanity, then it shifts to the people. So that's how the instruction, that's generally how the instruction will read. I can.
Well, I have the Colgy instructions in hand.
This is from a case. It says the law presumes everyone to be sane. However, after some evidence of insanity is introduced, the burden of proof is upon you to prove to the satisfaction of the jury beyond a reasonable doubt that the defendant was sane at the time of the commission.
Okay. And as I described or informed many of the jurors, I could not remember. It's actually an elemental, and I couldn't remember how the elemental read. And I have the Colgy instruction in my hand right now. And it says, when the jury is instructed concerning the affirmative defense of insanity, the following language should be included as the final element of the offense. And the instruction is, and that the defendant was not insane as defined in instruction blank. And then you give a different instruction on the affirmative defense of insanity. And it starts out with the defendant in this case has raised the defense of insanity as defense to the crime. And you're supposed to put in the language And then it defines what insanity is. And I think that this guy, well, I think we've all made our records. I think he understands it. I think he's having, I think he says, I just want to see the evidence, but I think he seems to understand it. So we've all made our records. You withdrew 32.
Questionnaire.
Right. Next one is 44.
Similar, but I think it's even stronger case. Start by looking at a questionnaire. Like any investment person. Went into some pretty specific detail about what she remembers about Felicity. Into answer number question 21 is no. I think what is really important, Your Honor, big money. To help cover the cost of looking at posters. Some
So, yeah, based on her donation, I think it's.
Yeah, it was, that was problematic for me too. Okay. So juror 44 will also be struck, and then juror 57.
I'm not gonna believe she just win 21 because she'd be very if she's.
Right, prosecution.
Back to your inquiry with her. Said I have a. Listen to the evidence before.
Well, I had an extensive, well, not extensive, I had a dialogue with her largely because of question 24. Because she's the one that said yes, no, and possibly. And so I had a question, or I had some discussion with her, and it seemed to me to be clear to her that she was not exactly sure, or that when she filled this out, she had not yet been instructed on the law, that she was able to set aside any preconceived notions, and that she would be able to look at this case based on the facts and law in this case, and then make a determination. So I will deny the challenge for cause as to 57. I will further question jurors 8 and 12 in a and I thought that you had raised an issue with juror number 8 as to violence to children, but that's not on his questionnaire.
Not violence, it's question.
You said all it says is child abuse. Is there any specific type of case where you do not think you could be fair and it says child abuse? Okay. All right. Well, I'll follow up with that. And then question 12, who is, or not question 12, juror 12. This is going to sound like a stupid question, but who is the son? Last name?
ROWA. He was signed to juvenile and on military.
Okay.
Maybe because my questions, I've got some issues with it.
It crossed my mind. Crossed my mind.
Sometimes I don't ask the best questions, but she seemed to not
No, I was watching it and I had the same. Okay, we'll just release her. Okay. And it's always a difficult issue because you don't want to be patronizing or insulting. Um, so, so at this point, we have excused 10, 18, 53, 23, 45, 16, 41, 66, 44, and 25. 45 was mentioned earlier. $25 and $44. Okay.
Just one more thing.
Go ahead.
And of course, been further part of your number.
Yes.
I would have yet to vote
Okay. Are you doing okay? Okay. All right. Let's go ahead and bring the jury back in. This is. Six, seven. Okay, record should reflect the jury has returned to the courtroom. I wanted to follow up with some questions on a couple of people. Juror number 12, you said that your son-in-law works for the DA's office. Do I have that right? Okay. And how long's he been there? Okay. And have you discussed or has he mentioned anything about this case to you at all? Okay.
Don't discuss cases.
Okay, that's fair enough. Then the next question is, you know that guy over there is his boss, right? Obviously, there might be a concern about how it would look. Is your son maybe? And I don't want to. Whether your son is working at the same office and you come back with a particular type of verdict. Do you have any concerns about that?
It's son-in-law, not.
Son-in-law, I'm sorry. Son-in-law, do you have any particular concerns that you might be influenced? Maybe think that you need to come back with a particular verdict so that it works out well or better for your son-in-law at the DA's office? Okay. And then juror number 8, I wanted to ask you a couple of questions. And I know that you get these questionnaires before you're ever instructed on the law, but I wanted to ask a couple of things. One, you said in response to one question, is there any specific type of case where you do not think you could be fair? And you referenced child abuse. And obviously, there are some allegations. There's actually even a charge of child abuse in this case. How do you feel about that? Okay. Okay. Now, obviously, one of the issues would be from the defense standpoint is because this case does involve a child and there's actually a child or a charge of child abuse in this case, there might be a feeling that you would not be able to presume her innocent. Can you presume her innocent? Then the other question, and this relates to the next question, in response to question 21, you said that you had seen, heard, and some things about this case, and you were asked the question of whether or not you would be able to set that aside and render a fair and impartial verdict based only on the evidence presented at trial and the instructions of the law given to you by the judge. And you said, I could try, but I'm not sure. Do you still feel that way? Okay. All right. All right. So here's what we're going to do. Give me a minute. Okay, we're going to do this a little bit different. If council will approach, please.
I hope he reads who is left and not who is getting deleted. That way I can double check my count. But if we're only losing 11, then that'll put us at 21. And even if we lose those other two as well, I mean, that's still 19 today, which is a really good number and keeping us at our average. So we likely will be done with this on Monday or Tuesday. So I'm really excited about that we will get one step closer to the next thing. And I'm sure that BC, if she's listening, is excited too, because she is like losing her mind with the jury
Okay.
selection stuff.
So here's what we're going to do. And we're doing this sort of in two groups. And this is the first time we've had to do it in two groups, and it's because it's of a logistical issue. So bear with me stumbling through this. So what I'm going to do is announce when I need to come back. And the process will be, if I your number, you need to stay here. And that's your number. And I've gotten to you. Don't need to stay here. And the reason for that is, yeah, easy as pie, right? Okay, here's the deal. We are bringing back, because the courtroom can only hold so many people, we're bringing back 75 jurors at 9 o'clock on April. Bringing back the remaining 30 at 11 o'clock on April. that we're bringing back. That group is people who are going to apply group. And I haven't announced. Okay, so the people that will be coming back at 9 o'clock, you're number 2. 11, 12, 20. If I called your number.
It's 47.
Body from passing out
No, stay with
just a sheet, yeah, so that we can gather contact information. Yeah, because that's the, it does some way, you know. They also use. It's possible that something may. Something comes up. We will see you back on April 3, and before I dismiss it, I'm going to give you
I don't.
Oh, okay. Okay.
Hi, baby.
Yeah, say hi, everybody, huh?
Hi.
You can't hear the judge, but it's kind of ironic that I'm like, man, I hope we can hear everything, or whenever they read the numbers, and then it's like sound cuts out. Come on, guys. Yeah, I'm thankful too, C-Dub.
Watch it.
I'm gonna go out on a limb and say that if there really are any families watching, any of the family, that they're probably just as frustrated, if not 1,000 times more than us. I did, C-Dub, I did. You found it. Good job.
High five.
I really did. And what's even worse is I was getting ready to start typing the numbers, and my husband is under the house right now, and he called me and he's like, "Can you go in the closet and flip the breaker?" And I'm like, "No, I have to write down the numbers." So then I had to rewind and re-listen to it from my phone, so I could get the numbers, and I get to it and it's like 2, whatever, 8, 10, 11, 12, 20, and then nothing. Then I couldn't hear nothing. I'm like, "Seriously, Judge? Where did you go?" Monday was the best microphones for us, but that we could hear the lawyers talking, and they were still worried about that, but, like, we're gonna have to figure something out because this isn't gonna work. I'm sure they're not gonna make them stand at a podium the whole time, and if they're walking around the courtroom, are we gonna not be able to hear whenever they're questioning witnesses and stuff like that, or talking for their opening statements?
Yeah.
Oh, yeah, Emily, I agree. Hearing the questions and answers are the best, from the defense and the prosecution. Leticia's in there. That's one thing I know. Um, Honestly, I've been curious all day, like, if anybody who has been dismissed from the jury has come to YouTube to, like, watch the jury selection finish out or anything. So if you're here from the jury, shoot me an email. I wanna chat. Like, from, the dismissed jury. Please, if you're an actual juror member and told to call back on April 3rd, don't email me. I don't wanna get you in trouble, but anybody dismissed, I'm curious, like, about the questionnaire and different things like that. So I checked, Zach Dewpoint was who was in there the first 2 days, and he's not in there today. He wasn't there yesterday either. Um, he moved on, and he is covering the, um the Cruz trial right now. Cruz pled guilty to second-degree murder. So he's there tweeting that trial out, and then the other guy that was there on Monday apparently was terminated? So, or at least that's what Crime Curious said, that he was terminated, so, I don't know. Somebody needs to please get this judge some cold medicine. He seriously better not end up with, like, COVID or something. I will be, like, so sad. So, so sad.
Can you send me parts of the transcript? I'll send you an email about what part that I want.
Okay.
Can you segregate it out by juror?
Yeah.
Yeah, do a word search and do it that way. I'll send you an email. Oh gosh, no. Next week's fine. Yeah, no. Yeah, I'll probably send you the email tonight, and next week's fine.
Oh, yeah, that's true. I forget that it's allergy season other places right now. We still have, like, snow on and off.
Yeah, it just worked out that way. It just, instead of in the middle of a row, it just worked out that way. Okay. You've probably already guessed that there has been some public or media interest in this case. There could be more in the coming weeks. You must guard against that, as you will be required to decide this case based on the evidence presented and the instructions that I give to you. You can tell your friends and your family that you may be on this jury and how long you think it will go. You can ask for their help in avoiding exposure to stories or even opinions from others regarding this case, but you cannot otherwise discuss anything about this case with anyone. And you should not listen to any opinions regarding this case from anyone else. If someone asks you why, just tell them it's because that's what the judge told you to do. That puts the burden on me and not on you. You can still blog or communicate with others, just not about this case. You can't do any blogging about your jury experience or communication with other jurors. You can still watch TV. You can still go on the internet. You can still do your shopping on Amazon. You can still do all of those things. But if anything regarding this case comes through your feed, change the channel or turn the page, swipe right, swipe left, up or down, whatever it is, and do not give it any attention. You are not allowed to look at, read, consult, or use any material of any kind, including any newspapers, magazines, television and radio broadcasts, dictionaries, medical, scientific, technical, religious, or law books or materials, or the internet in connection with your jury service. I want to emphasize that you must not seek or receive any information about this case from the internet, which includes all social networking, Google, Wikipedia blogs, and other websites. You are not allowed to do any research of any kind about this case or this kind of case. So here's what you can expect. we're going to have all of you come back at different times on April 3. At that point in time, we anticipate the trial will be starting. I understood there was a question of how long will you be here on April 3? If you are selected to serve on this jury, you will be here until May. You'll get to go home. You'll be here every day until May. Well, you won't be here on Thursdays, and you won't be here on May 12 either. But other than that, you'll be here Monday, Tuesday, Wednesday, and Friday from about 9 to 5 p.m. That's generally what the trial days look like. We have a break in the morning for about 15 minutes or so somewhere between 10 and 10:30. We'll have a break somewhere in the afternoon for about 15 minutes, somewhere between 3 and 3:30. We'll have a break for lunch about noon to 12:15. That first day, if you are selected to serve as a juror, is going to be a very full day because we have to go through a process. It's truncated, but it's somewhat similar to the process that we went through today. If you are selected to serve as a juror, then there's, believe it or not, further instructions. And we'll show you how to get into the back hallway because we have 2 rooms back there for you. And Mr. Combs will take care of all of that stuff. So we'll see you back on April 3. Don't discuss case with anyone else. Don't do any research about the case. And you need to be in the hallway. You don't have to go to the jury assembly room like you did this morning. Just meet in the hallway. There isn't a good way to put it. Mondays are horrendous because it's one of the busiest docket days in the courthouse. If you were to ask Mr. Combs, we typically bring in about 320 jurors on Monday, something like that, because there are so many people that are calling jurors. So it's very possible that the hallways are really, really, really busy. Please wait. Please be quiet. Please be respectful because there is other business that's going on in the courthouse aside from just this case. But we will get to you, I promise. So with that, have a good week. We'll see you back on April 3. All rise for the jury, please. This is what I need. Is that enough? That good enough? Okay. Thank you. You may all be seated. Record should reflect the jury has left the courtroom. So what I will tell the lawyers is, by my count, juror 75 on Monday, April 3 is juror 47 over here. So those will be the first 75 jurors. Then juror 51 will comprise the first group, or will comprise the other, 30, 35 that we are bringing in on, or at 11 o'clock. So with luck, maybe we're done Tuesday, Wednesday, the latest. And anticipate spending some time together just on a couple of issues, primarily communications that I need to make to the various parties regarding relaying communications that we've received from jurors. Because we've had one juror that has had an employment status change. and another juror that, I don't have the comments in front of me and I don't want to misrepresent what the comments were. So, but I think it is important that the attorneys know what those comments were before they make a determination regarding who they want as a juror. So, is there anything else that we need to take up before Monday morning? Prosecution?
Yes, sir, briefly. Reached out to Dr. Torres and Dr. Gray.
The test, not the report, the test data.
Psychological test data.
Go ahead.
We don't have access. They have not received it yet. I'm concerned, obviously, that they haven't. It's the one item that sooner rather.
Mhm.
So I would just ask that we get it done. This Thursday. Some other items that I think something needs to.
Yep. It needs to be there no later than noon Mountain Daylight Time on what is next week? March 28th. So that would be Tuesday. So, and then if it's still a problem, they don't have it by noon on March 28th, you can bring it up and we'll deal with it on the afternoon. Sometime in the afternoon, we'll figure that out. Anything else from the prosecution? Defense? No? Okay, all right. Oh, you got to tell me when you're bringing in the autopsy photographs. I don't want you just putting those up or putting them out. And I know you know that. But and keep your victim's advocate attuned to when that's going to happen too. Yeah. I figured that. I thought that was the case. I just wanted to make sure. So, and I want to know before it happens. So, okay. Go ahead.
I have made a specific discovery request, and both Dr. Grimmett and Dr. Torres to, that the literature does not support this diagnosis.
Okay.
I requested that because of whatever literature they're referring to.
Uh,
Saying that they're referring to literature, I've requested it, that be turned over.
By noon on Tuesday, make sure both sides have exchanged it. I know it's sort of out of the ordinary and a little weird, but you know, the experts could actually talk with each other, and say, it would be. They could do that and say, hey, I don't have these test results. Can you send them? Yeah, I would. How about you send me those articles that you're talking about? But noon on Tuesday, we'll talk about it if it's still not an issue. So be in touch with your expert. The other option is, and the prosecution needs to hear this. The other option is if that's not produced and we get to that point in trial, it may be that they're not going to be saying anything about what other literature has to say.
Just in response, and I indicated this to Mr. Cellini, I think what he's referring to, the answer is going to be, it's their education and there's one piece of literature, but we'll confirm them to make sure.
Yep. And if that's the case, then it is what it is, and you get a cross-examine and say, you can't point to a single article anywhere. And it is what it is. All right, court will be in recess then. You get that to me by Monday?
Right now.
Perfect, thank you.
Morning, Jeff.
Okay, so what I picked up from that, sorry if I just ear blasted you guys. I always try to remember and I forget sometimes. Sorry. So it sounded like the prosecution was trying to get a report of some sort from their doctor, not the defense doctor. And it sounded like Mr. Tellini was saying that the defense doctor needs that report as well or whatever. And that's why the judge was like, they could just send it to each other. So it sounded like, but in my opinion, the prosecution just got like, I feel bad for the prosecution's doctor having such a small time frame to handle things in, because we've waited how long now for the defense doctor to turn things in. I could be wrong on this, but I had to go back and listen to it with earbuds, honestly, because it was so low. I wonder, actually, can I put that through like the audio mixer real quick and we can just listen to it? But either way, so Tuesday we'll be able to hear during jury selection what the outcome was. And Nicole asked, what they were saying was number 47 that was kept today is number 75 from the week. And so that was the last person from that group, or from this number 47 today was the last person in the first group of 75 that are going to have to come back. And so then after that, it started the second group of 35 that they're wanting. So I hope that makes sense. Yeah, doctors are busy anyways, and these circumstances yeah, exactly. Oh, you were behind in the stream. I'm so sorry, chaotic. I do that sometimes too. Like I'll out of nowhere, like I'll get a phone call or something like that, and then I come back in and it's like, crap, I'm 2 minutes behind, and like sometimes I don't even realize it. So I wish that there was a reporter in the courtroom, but there's not. So I can't even get confirmation about what we're seeing. Like there is nothing on Twitter about this. Let me see if I check the Gannon groups, if anybody on Facebook had updates or like a running stream or anything like that. No, not really. So let me see what this person is saying. So I mean, if they kept 21 today, I think that's what we said, right? But we couldn't hear, so it's hard to say. But that would give us 20, 18 plus 21 plus 21. I did let me see. That would give us 42, 62. Wait. Oh my god, I can't. Here we go with math again, you guys. Where's my calculator at? Whew. Should be so simple. Just small numbers, and I'm like, So I think we have 80 total, which means that we have 5 towards the 30. So yeah, 35 more jurors needed. Is that what he said? Right. Yep. Okay. Yeah, Lauren from Morpheo. You'll be in court at least once if you can get in. That's not enough now. Once they are streaming the actual court process, I am hoping and praying that it will be better. But right now it's just hard. It's just hard. Because they're working on the mics. I really do hope that they fix the mic setup for Monday though. Because that was terrible. I hope the family like gets on Mike Allen or something to tell them like, hey, couldn't hear nothing. Please fix this. But does anybody have any questions that I can answer? I can go backwards. Let's see. What was I gonna do here? Take this down. And let's stream this for a second. If with the closed captions up, we can maybe.
They're bringing in on, or at 11 o'clock.
Saying that they're referring to literature I've requested it.
Bad for the prosecutor.
When that's going to happen too. what those comments were before they make a determination regarding who they want as a juror. So is there anything else that we need to take up before Monday morning? Prosecution?
Reached out to Dr. Torres and Dr. Gray.
The test, not the report, the test data.
Psychological test data.
Go ahead.
We don't have access. They have not received it yet. I'm concerned, actually, that they haven't. It's the one item that sooner rather.
Mhm.
So I would just ask them to get it done. Thursday.
Okay, I can read the charges. Yes, sorry, I wanted to listen to that part again. So it sounds like the prosecution doctors, Dr. Torres and Dr. Gray, I think he said, are still waiting on one of the reports that are from the defense about this doctor that the defense team is using. And so that's what they said. It wasn't the prosecution doctors were waiting on the prosecution. They're still waiting for something from the defense. So she has till Tuesday to put it there, or else she cannot talk about her history or any articles or whatever the judge said. So that's good to know. Good to know. I hope I almost like I don't know. I want T to have a fair defense, but at the same time, like I would rather this doctor not be able to testify about certain things. So that makes it hard too. Okay, so charges. Let me get this. Yeah, wild. I know. She is like playing games for real. Okay, so this is T Stauch's actual charges. So she's being charged with 13 different things. Count 1 and 2 are both murder in the first degree. Count 3 is child abuse resulting in death. Count 4 is tampering with a deceased human body. Count 5 is tampering with physical evidence. Sorry, let me close that real quick. Okay. Count 6, 7, 8, 9, and 10, and 11, 12, and 13 are all crime of violence. So the last 7 charges are all crime of violence. And so let me read down through these. So it says murder in the first degree. The first one says that she unlawfully, feloniously, after deliberation, with the intent to cause the death of a person other than herself, caused the death of Gannon Stauch in violation of Section 18(3-102). Count 2 of murder in the first degree is because he was under the age of 12 and she was the person of trust with respect to the victim in violation of Section 8(13-102). Child abuse resulting in death. It says on or about January 27th, she unlawfully, feloniously, knowingly, or recklessly caused injury to or permitted to be unreasonably placed in a situation that posed a threat of injury to the life or health of a child, namely Gannon Stauch, and engaged in continued pattern of conduct that resulted in cruel punishment, mistreatment, or an accumulation of injuries that resulted in the death of a child. Count 4 was tampering with a deceased human body. On or about January 27th, she, believing that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, unlawfully, feloniously, willfully destroyed, mutilated, concealed, removed, or altered a human body and part of a human body or remains with the intent to impair their appearance or availability in the official proceedings. You see when the date of this is. This is from 2/12 of 20. I think. Wait, hold on. Just want to make sure I'm reading the most up-to-date thing. So then it is count 5, tampering with physical evidence. On or about January 27th, she believing that an official proceeding was pending or about to be instituted, destroyed, mutilated, concealed, removed, or altered physical evidence with intent to impair its variety and availability in pending or prospective official proceedings in violation of the section number. On January 27th, for count 6, crime of violence, she used, possessed, and threatened the use of a deadly weapon, namely a firearm, during the commission of an attempted commission of conspiracy to commit, or the immediate flight from the offense, murder in the first degree, after deliberation. So basically, she threatened him with a gun or used a gun. Crime of violence, count number 7, that she unlawfully used or possessed and threatened the use of a deadly weapon, namely a blunt instrument, during the commission of an attempted crime. This time, for this crime, it was murder in the first degree. Count 8 is possessing or threatening the use of a deadly weapon, namely a knife or other sharp instrument, during the commission of a crime. And this one is first degree murder. Count 9, crime of violence, that she attempted the commission of conspiracy to commit or immediate flight from the crime of murder in the first degree, after deliberation, as charged in count 1, unlawfully caused the death of Gannon Stauch, a person not participant in the crime, violation of that section. So basically, she stopped him from being able to leave while she was trying to kill him. Count 10, crime of violence, is that she possessed or threatened the use of a deadly weapon, namely a firearm. So they had 2 different firearm ones. The next one is a different blunt trauma one, and another knife sharp injury one, and another flight. And the reason that they're all doubled is because she has 2 different first degree murder charges. One is for the fact that she was his caregiver and he was under the age of 12. And the other one is because it was, let me go back to that so I don't say it wrong. Because she intended to cause his death. So that's why the charges at the end with the weapons are doubled. Hi, Sherry. How are you? Yeah, finally caught up. We're about to end. But these are her crimes. You know, this is what she is being charged with. And it just really tells you, I mean, between this and the arrest affidavit, they have so much on her. So much. So, yeah, wow. But ooh. So we will do a members only live tomorrow, you guys. Just whenever we do our members only lives, we just kind of hang out, and sometimes we'll play games, sometimes we will just chat and things like that. Yeah, they charged her with murder 3 different kinds of ways. Exactly. Can Letecia claim ineffective assistance of counsel down the road for her lawyer saying her last name wrong? I don't think so. I don't think that'll count. He does say it wrong all the time, though, and you would think after working with her for so long that it would be easier. Hey, be nice to her, please. She's not hurting anything. One baby crawled into the other baby's bed, and she's like, "Shoo, get away from me." Yeah, it is heinous. You can't help but be torn on this one. Yeah, everyone is too. Exactly. What a day, you guys. I really hope they fix the mic situation, though, because it's going to be brutal if they don't. Absolutely brutal. So I will see you guys all tomorrow at some point. I do want to try to get a few short videos done at some point too, because there are so many missing and so much going on in all the other cases. getting really concerned about Scotty and the fact that he still has not been found. I know we've been sharing his flyer, but we need to talk about Scotty and Oakley as well. You know, her mom was arrested today. They found her. She was in North Carolina, but they still have not found Oakley. And so I'm just hoping and praying that this is not another filicide case. Like, I'm so tired of these parents hurting their kids. And it just blows my mind that we're looking at potentially another situation where is this baby at? Why is she saying that she dropped her off at a hospital? And then why haven't they been able to find her? Does anyone know if the verdict has a form of not guilty on it? I don't think so, Emily. Like, I don't think that there's a chance that she walks out a free person, but let me double check. So the difference between not guilty by reason of insanity, it looks like she would go to the hospital, and then she would get a chance each year to get out of the hospital. Whereas if she's not, then that won't happen. Sorry, let me show you guys this. Emily, thank you so much. You've been so generous today. I really do appreciate all of your support and love and just being here, honestly. Just being here. It does make a huge difference. Every single little bit of support. Okay, so it says, ooh, here it is. Okay. Under the first prong, the defendant's mental capacity and to distinguish between right and wrong is measured against the societal standard of what is right and wrong. That is not a subjective standard. Under the second prong, they cannot form criminal intent. And so then it talks about different things like severe neurological disorders, schizophrenia, bipolar, poisoning, or any other medical condition that produces serious delusions or a break with reality. Insanity is not the same thing as mental depravity, passion of growing anger, rage, hatred, or other motives, or moral oblique. I don't even know. I'm not even going to try to say it. So then once they decide that you are insane, the insanity plea in Colorado is an affirmative defense. This means that the defendant admits to having broke the law, but his or her insanity excuses any criminal liability. For example, Helen suffers from paranoid schizophrenia while in the supermarket. Helen has a delusion that a killer is coming after her with a knife. This causes Helen to flail about, knocking a nearby shopper to the floor. The shopper files a police report and Helen gets charged with assault. At trial, Helen's attorney presents evidence showing that she was in the throes of a schizophrenic delusion. An element of the assault is that the defendant had a specific intent to touch the victim. Here, Helen had no intention of touching the shopper. Instead, her mental condition caused her to flail about. which then caused her to inadvertently shove the shopper. Since Helen's mental illness prevented her from forming criminal intent, the mens rea, the jury finds Helen not guilty by reason of insanity. So, let me see. What happens to defendants found not guilty by reason of insanity? When defendants receive an acquittal by reason of insanity, the judge may commit them. So they don't necessarily have to commit them, but they may commit them to the custody of the Department of Human Services or have them evaluated as an outpatient. So it does sound like if she is found not guilty by reason of insanity, that she could potentially go home. It's going to be up to the judge if he has her seen as an outpatient or an inpatient. Do I think Judge Gregory Warner is going to let Letecia Stauch walk out rather than go to a facility? Absolutely not. But that is one of the things, right? So acquittees who get committed go to a mental hospital, such as the Colorado Mental Health Institute at Pueblo. That's where she's actually had her evaluations done for competency each time. And they will remain there until, if and when, their condition resolves. This could be for a longer than what the prison sentence would have been. Some people remained confined for life. So, I will tell you, the Mental Health Institute at Pueblo, it does not have very good reviews. We had looked this up a while ago. It does not look like a happy, cushy place to be. But the issue that I have is that she would remain there until her condition resolves, which means she could potentially get medicated, act like a normal human, because we all know she is capable of acting completely sane, and then be let out, because that is the only condition of how long they stay there. So rather than facing a life sentence for all of their issues and things like that in prison for everything that she has done, she could potentially get medicated and then convince them that she is sane, she is healed, blah blah blah, and be out on the streets in a year or be out on the streets in 5 years. And she does not deserve to ever 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 get out and walk around this planet ever again. Ever again. So, I hope that answers your questions, Emily. Yeah, that's scarier. Holy cow. Right. No, yeah, I appreciate that, Emily. Trying to share the love. But the thought of her, like, even having the potential, though, to walk around is just, ugh. But I know I don't picture Judge Warner sending her home. Not a chance that he would let her be an outpatient. Not a chance. So. But anyways, you guys, so I will see you all on Monday. If you don't join us in between then, I will be live at some point tomorrow. We'll definitely do a members only live for those of you who have joined. I totally appreciate each and every one of you guys. And yeah, I love you guys so much. I'm sorry. My brain's like so let me see here. You think she would be offed by someone, Amy? Short and Google, yeah, about the insanity defense. Here's the article here that I'm reading. This is from like lawyers that are explaining it. Hi, B Tim. I didn't even know you were still here lurking. According to an 8-state study, the insanity defense is used in less than 1% of all court cases, and when used, only has a 26% success rate. Wow, that's a tiny, tiny fraction of cases. And with that being said, it makes you really sit there because she kept talking about how she had an ace in the hole. That was her famous saying over and over again. And her ace in the hole, I guess, is what? Because this is not an ace in the hole. She can't. Yeah, you can say that's a lot of people's fear, that every year to put the family through that. Right. the possibility of ever being released exactly. But all right, guys, I love you so much. Yes, I am going to go be with my family. I love you guys so much, and I will talk to you all at least on Monday. Have a good day.